Indeed, it is a supreme battle at the Supreme Court. All eyes will be focused at the Apex Court. For the third electoral cycle in a row, we have ended up in the Apex Court seeking a political and constitutional interpretation in regards to the presidential election. Good morning. This is KBC. This is Kenya Decide, a special edition on News Check. And of course, from today for the next 5 days, there will be a hive of activity at the ceremonial hall at the Milimani Court, where the Apex Court is domiciled for the next 5 days. And we're expecting an answer to all our prayers as Kenyans, so that we may know what exactly transpired after we peacefully voted. But how has the journey been? Of course, since when the court said that 14 days are the one allowed in law to actually file the petitions and also hear and determine. 14 days, we only have 5 days. Where are we? How has the journey been? Let's first of all take a closer look at how things have been panning out since the filing of the petition. This is the court timelines after the petition was filed on the August of 22nd. Actually, it was the last day. They had a day to serve the respondents. And of course, there being 9 petitions, 8 seeking to nullify the presidential election, and 1 seeking to actually strengthen that and affirm that. On 27th, responses to petitions were filed and also served. Remember, the timeline's quite tight. And of course, the responses have been done. And also, remember that we are also seeking to have people who want to be enjoined in cases as well as friends of the court, being the amicus curiae, or in plural, here it's amici curiae. And after that, on August of 28th, rejoinders were filed and served. I do remember including Moses Kuria, the Attorney General. After, of course, a petition has been filed, the responses also have to be filed as well before the Apex Court could hear. That is August of 28th. And then August of 29, that was yesterday. If we can have that slide. Yeah, the interlocutory applications filed and served. And we also had the Chief Registrar of the Judiciary, Madam Ann Amadi, talking about how things are going to be panning out today in the pre-trial conference. 20 interlocutory applications have been filed. So today we have the pre-trial conference. Basically is housekeeping. A lot will be centered on how the case will be managed by the 7 judges. And tomorrow, August the 31st, third party or friends of the court applications are filed and served, and we'll be hearing which will be struck out and who will be allowed in the court. But so far, friends of the court, including the Law Society of Kenya, some will be allowed to give their submissions, but others will oral submissions, but others will only be allowed to give their written submissions. 14 days, remember, hearing and determination of the petition. We have 5 more days left, and the deadline to render a verdict will be September the 5th. We're talking about Monday, this coming Monday. Those are just some of the court timelines that the Supreme Court will have to observe in the next 5 days as we wait for a determination on the same. How things will be panning out, that is what we will be discussing, or will be forming basis of our discussion this morning. At about 10 some minutes past 10, we only have less than an hour until we head to the Supreme Court so that we may know exactly how things pan out there. We are expecting the 7 judges. Actually, the first time that we are having 7 judges. In 2017, we had 6 Supreme Court judges, and of course, we will be breaking down all that right here. My name is BenTroy Njue, welcoming you for this live coverage, and I'm not alone. As usual, we have a panel of experts, and to begin with my immediate left, we have Dr. Churchill Saoke, who is a leadership and governance expert and also a lecturer at the Jomo Kenyatta University of Agriculture and Technology. Karibu sana, Doc.
Asante sana.
And on my extreme left, we have a constitutional lawyer. He's also a policy and governance expert, Wambui Shadrack. Karibu sana, Wambui.
Thank you, Njue, and a good morning to our viewers and listeners back at home. Asante.
Well. From today, we'll be having those big words. We have the brilliant minds. Over 100 lawyers have been in this case. But earlier on we were talking, and you told me that there's something that you also guys, in one way or another, you're touched or in the case.
Yes. On Friday last week, we had filed an application which was actually listed yesterday before the Supreme Court judges. It is an application that was made by Inua Mlemavu Initiative, which is an initiative that is meant basically to ensure that they advocate for the place of the disabled in our society. Remember, we had the elections on the 9th day of August, and speaking specifically to my situation, I voted at Kiboro Primary School here in the Mathare constituency, and the polling station we were voting at did not have ramps, so to say, and you will only access these polling stations by the use of staircases, so that people who are disabled or physically challenged and enjoy their freedom of movement through the use of wheelchairs could not easily access these polling stations. You will also recall that I know you also participated in the just concluded elections, and one thing that is for sure is that we did not have a provision for braille reading of the ballot papers, so that any blind person will not know for a fact that he is indeed voting for either William Samoei Ruto or Right Honorable Raila Amolo Odinga. So to that extent, the disabled felt that they were excluded from that very important exercise, and to that extent also, they called to question, or they are calling to question the election, or the presidential election as we have seen it. Yes, just that is basically it as far as our involvement in the Supreme Court is concerned. But what is important is the Supreme battle, as you put it. Yes, we are in a very important phase of our democratic governance, and I mean, elections do not really end at the ballot. We have invited the courts to also help us in deciding whether the declaration of someone, whether he was elected invalidly or not, is reserved for the courts to determine. So it's a good thing for democracy. It is a good acknowledgement for the length that the courts have, the place of our courts in our current constitutional democracy. You will recall that in the year 2007, the reason why the Right Honorable Raila Amolo Odinga chose to rally his supporters and to go to the streets was basically because he did not have faith in the judiciary then. So right now, with the current focus being at the Supreme Court, it's a good show. It's a good show. It's a demonstration of the confidence that we have in those Supreme Court judges. We are hoping now that there are 7, at least with a split, because they can even get to a split decision. So that with a split decision, then I think we'll be set to go, because we have an odd number, other than the even number that we had in the year 2017. So I think it's a good thing, Njue. Yes.
All right. Doc, I would also want to pick your mind on your opening statements in regards to that. And of course, we have our crew that is domiciled at the Supreme Court, and we will be crossing over there, but as soon as there is some life there, We will be crossing over. As you can see, those will be, or that will be, the home for the 7 judges of the Apex Court for the next 5 days. That is a ceremonial hall at the Milimani Law Courts where the Apex Court will be sitting for the next 5 days. Doc, to pick your mind on your opening statements, interesting time as Wambui has talked about, and it's the first time that we are going to the Apex Court with a divided commission.
Well, yes, first we have to admit that this is a very important process for the country. One of the things that we have always emphasized in many areas where we have an opportunity to advise policymakers is that the legitimization of government from the times of the ancient states to the development of nations today, legitimization of government, that process is very significant. Because if we get it wrong, we will never get anything right. If we get it wrong in the legitimization of government, that process, we never get it wrong anywhere. So this is therefore very significant for this country. The other thing that is important to mention is that our country, our democracy has really grown. You know, where we are seeing an election not as an event, but as a process that requires a holistic view, that procedures have to be followed as laid down by the Constitution and also by the operational principles of the agency that is that deals with the election. So these are very key gains that this country has to be proud of. You know, the fact that if an election is contested by a party, the whole country can have faith in the supreme judges. It is something to be proud of. Because anyway, the alternative, as Wambura says, is chaos and anarchy, which is not something that any country will want to go for. So I think that we need to look at this process with a lot of purity, with a lot of esteem, because the decisions that are going to be made today are not just for today, but for posterity. You have seen previously, you know, the decisions that have been made by courts have influenced other preceding decisions. So everything that is every judgment that is going to be made by the Supreme Court judges, it's not just about who won the election. It's not about who lost the election. There are other things that are going to affect many things on how the conduct of elections will be undertaken tomorrow. And I think we need to see that holistic view, and know that what is going to be done at the Supreme Court is just beyond a win of election or a loss of election.
Now, Wambui, looking at what Anna Amadi was talking about, what we expect as Kenyans, and of course what we expect at the courts today during the pre-trial, she did mention about even the observer judges coming in. Yes. And the latest news that we have from the Apex Court is that some of the petitions have been struck out already. A good example is the Moses Kuria one. And you are in a better position as an advocate of the High Court to tell us exactly what has led to the striking out of Moses Kuria petition without even, first of all, having to hear it.
Yes. Now, Njue, yesterday, of course, we had the views of the registrar, Anna Amadi, informing us, of course, telling us what we should be expecting today, and we have seen. There had been mention of a number of advocates representing different sides. We had about 54 representing, Raila Amolo Odinga, and then we had a number also representing, William Samoei Ruto. So in order to curb, or rather to control the number of people who are going to participate in the process, there was need and wisdom to give us some direction so that we do not have a place that is clogged with individuals who are, some of them who will not even be participating meaningfully into the process. So what we saw yesterday was just organizing the house so that we will be having lawyers a majority of lawyers will actually be sitting outside as opposed to inside. In fact, if you look at that room, the room that they have chosen is small as compared to the place that we are conducting the BBI, the hearings by the Supreme Court on the BBI. So this is, in a sense, should tell you or should inform you that you expect to see a slim number of advocates either arguing for or against the petition. So for each party, they will only have 4 representatives getting in. So you might not see many of the advocates who are going actually to be preparing, the ones that are going to be making the submissions in court. So that is one thing that the viewers at home should be expecting. Now, going specifically to even the determination of a number, there has been a number of decisions, rulings that have been made very early in the morning.
Yes.
By the Supreme Court judges. And this is also to ensure that they limit the number of people who are going to get into or get access into that courtroom, the ceremonial hall. So specifically speaking about the Moses Kuria ruling, there was a preliminary objection that was filed by my senior, Mr. Paul Mwangi, mentioning that the Supreme Court did not even have jurisdiction to deal with the petition as it had been filed by Moses Kuria. And just but to give a panoramic view to the viewers and to the listeners who are listening at home, Moses Kuria's petition only focused on the violence that took place at the Bomas of Kenya. It only called to question, Right Honorable Amolo Odinga's agents for having participated in those, the violence that we experienced or we saw in our TVs, on what was happening at the Bomas of Kenya. So he sought, in essence, for the court to direct the DCI and the DPP to take action against the Raila Amolo Odinga and his agents. This should be Dikembe, if I'm not mistaken. So that if you look at the authority of the Supreme Court right now, the authority that it is exercising right now as given or donated by the Constitution, and specifically speaking Article 140 of the Constitution, proceedings that are ongoing before the Supreme Court are just unique in themselves. They are guided by some certain specific rules, the Supreme Court presidential rules, and they are guided by the Supreme Court Act and the Constitution. So that the only thing that is up for challenge at the Supreme Court right now is the declaration by Mr. Chebukati Wafula Wanyonyi declaring Ruto Samoei as the president-elect following the elections of the 9th day of August 2022. So that is the only thing that is up for challenge. So in the Solomonic wisdom of the Supreme Court judges, and I agree entirely with what they have decided, is that the petition as filed by Moses Kuria is actually is just but misguided. It is misadvised. It should have been filed, if at all, before the High Court. And this should be in special circumstances. If the DCI has refused to take action against people who perpetrated the violence that we saw, if the DPP has also refused to take action against the violence that we saw, those are the special circumstances that the petition, if at all, will have found itself before the High Court and not the Supreme Court. So because the Supreme Court is exercising some special jurisdiction or special authority, then it makes sense for now to dismiss it, to strike out that petition, because in a sense it is a waste of the court's time. It is just but going to clog and frustrate the slim timelines that the court has to hear and determine a number of petitions that have been filed before the court. So really we either make oral submissions just to highlight what we have pleaded before court, or the court in its wisdom, and of course being guided by the timelines, the strict timelines, the court can actually retire to its chambers, read the submissions that have been filed, because the submissions essentially bear in mind what you're going to be telling the court. So if the court now has seen what you're going to tell it, and has seen that it does not make sense to give you time to make those submissions before the court, it has the authority under the Supreme Court Act to strike out those unnecessary pleadings that are being made before the court. And another thing that is perhaps even most important is that there were further affidavits that were filed by Cherera on behalf of the 4 dissenting commissioners. And these were made in response to an affidavit that was filed before court, making mention that a number of persons in the National Security Council had visited the Bomas of Kenya, with a view of either intimidating or cajoling or persuading the IEBC chair to make some certain directives or declarations as opposed to those that the will of the people desired. So the Supreme Court has, of course, invoked its special and inherent powers. It has some special powers in it, powers that are meant to ensure that we administer justice in a proper manner. So that what the Supreme Court has said, in as far as, of course, the Supreme Court presidential rules or regulations do not allow for the filing of further affidavits. These are further averments. I want to simplify it for the sake of the viewers.
Yes.
Affidavits are just but sworn statements. So that the rules do not allow for the filing of these further sworn statements. But in this special circumstance, because there has been an adverse mention of some of the commissioners, because it was intimated that all the commissioners were present during that meeting, and Sherera is actually disowning those statements. So for good order, the court has allowed those affidavits. It has again gone to the extent of allowing the previous affidavit that had been filed by Cherera in the group. Remember, the position that had been taken by counsels representing the president-elect, Dr. Samoei William Ruto, is that the only responses that should be considered by the court are those of the IEBC and those of the IEBC chair as the returning officer in the presidential elections. But the court has gone beyond that. It has said, no, because we are after, looking for the truth. We are after establishing what the truth is in this case. Then there is no prejudice. You will not suffer any harm if we proceed to consider the affidavits. In any event, you have already responded to those affidavits.
Okay.
Yes.
And speaking of the commission, Churchill, IEBC in 2017 had a backlash, and even when the Supreme Court ruled and judgment that talked about we have to go back, we have to go back to the courts. Looking at IEBC and the allegations that we've had, of course we've had that the commission, and they haven't denied, because the day before yesterday, on Sunday, yes, I was at that presser where Tuju said, yes, indeed we met. Chebukati has said, yes, indeed we met. Looking at the commission, how does a referee, a Kenyan will ask, why would a referee want to meet any of the players in the middle of the game? How does that dent IEBC? We have the Venezuela case, which DCI has probed, and we even had 4 commissioners who left in 2017, eroding the confidence that IEBC enjoys.
Well, those are issues that, and it's good they are coming out at this stage, because as I told you in my opening statement, is that this petition is going to open a lot of things that had never been known about elections in this country, and it is going to set a lot of precedents on other preceding elections in many ways, and one of which is the fact that, as you have said, for the first time we are having a divided commission. 2, we are having even commissioners and people coming out with sworn statements, affidavits, indicating that there were people who were met somewhere and things like that. These are things that have never happened before. And I think it is good that they are coming in the year 2022, so that we use them to sanitize the process of election in this country. Because I can assure you that Kenya is bigger than these kind of things that we are seeing here. Look at the level of dignity that Kenyans handle the elections. Kenyans, the level of dignity with which they go to cast the ballot and go back home. It is so unfair and very unfortunate to hear that, commissioners who are bestowed with the responsibility to be the custodian of the will of the people can still go behind the scenes and meet the very same people or the very same key election actors who they should be independent from. It's very unfortunate. Because it means that, you know, the Independent Electoral and Boundaries Commission is only independent if it acts if it acts on behalf of the voters. But the moment it acts on behalf of the players, it fails to be independent, irrespective of which player it is acting on behalf of. So I think it is good that these kind of things are coming up, so that moving forward we set a precedence on how the Electoral Commission should handle the process of election. And it is good, and that is why even the judiciary should look at all these issues. Because you see, there are a lot of things that the constitution making is always something that is a work in progress. And you will always find that there are newer things that come up that need to be sorted. When you look at how the judgment of the 2017 influenced the election process of the 2022, somehow it helped in many ways. But then we are perfecting it. So the issues arising about the IEBC officials meeting key election players, and these affidavits that are now coming that are bringing a lot of secrets of the underhands that were happening, are things that actually the judiciary should actually use to help sanitize the process. Because in the long run, it is about defending and safeguarding the will of the people. You know, the whole question about the will, it is something very deep and something very dangerous. You have learned about the will of the people. The will is something that if you try to go against it, people are able to die for it. So if you are given a chance to safeguard the will of the people, it is something that you should take as sacred.
Indeed. And looking at the timelines that we've had, in any case, 14 days, are they quite sufficient? Looking at the mountains, Azimio brought their petition in a lorry. And leave alone that, there are other petitions. And yesterday, Anna Amadi talked about 20 interlocutory applications, which the court will have to sieve through and ensure they do all these pre-trial today. Of course, they have to listen to the amicus curiae and other applications. They have to hear the case. They have to make a determination. All this in the next, 5 days?
Well, Njue,
and perhaps we can first of all have the story on what Anna Amadi yesterday talked about, so that we may have a good footing in that, where the pre-trial conference of the Azimio la Umoja One Kenya Coalition Party leader Raila Odinga's petition against the Independent Electoral and Boundaries Commission (IEBC) and 8 others has been scheduled for 11 a.m. today. That's about 34 minutes and counting. Among housekeeping issues to be addressed are the interlocutory application and anyone seeking to be enjoined as amicus curiae or friend of the court, as well as set timelines for each petitioner and rebuttal. You'll also see the allocation of time and which matter will take precedence during the trial. Let's first of all listen to this story filed by our own Sarafina Robi.
All eyes will be on the Supreme Court starting at 11 a.m. as the pre-trial conference of the presidential petition, followed by Azimio la Umoja's Raila Odinga and 8 others, commence. The whole bench of 7 judges of the Supreme Court will hear and determine the presidential election petitions filed. Unlike the 2017 presidential petition, where only 6 judges were involved in the election petition.
All the 7 judges are expected to participate. Remember, in the last season, we only had 6 judges participating. This time round, we expect all of them to be present.
The Chief Registrar Anna Amadi further confirms that about 20 interlocutory applications have been made and the rulings will be sent electronically.
Interlocutory applications are applications that happen before the main hearing to sort out issues that a particular party would have an interest in. For example, if I want to join it as an interested party, that decision has to be made before we go into the hearing proper. As at 11 o'clock, all the rulings relating to the interlocutory applications shall have been delivered so that the pre-trial session begins without any pending applications.
The pre-trial conference will also address issues of the amicus curiae, which means friends of the court, as well as housekeeping and brigades to time allocation during submissions.
There are some who are seeking different orders relating to the scrutiny of the votes. So these applications are being considered, and all the rulings will be delivered to the respective parties electronically.
Given the limited space at the ceremonial hall where the hearing will take place, only 4 lawyers from each party will be allowed. Petitioners, respondents, interested parties and amicus curiae, as well as 11 observers, including a regional trial observation mission consisting of a high-level panel of eminent African jurists who are members of Africa Judges and Juries Forum, led by retired Chief Justice of the Republic of Tanzania, Honorable Justice Mohammed Shande Othman. Members of the public have been advised to follow the proceedings from their homes, with security being beefed up to ensure the process is completed without interference.
We are allowing the media to broadcast the information to the public, so if people can just listen from the comfort of their living rooms, it will help us quite a bit, because we don't want to run into problems with crowd management.
Following the strict timelines, the hearing will kick off immediately, with judgment expected on the 5th of September.
That the story filed by Sarafina Robi there, Anna Amadi, responding to some of the questions in regards to the housekeeping, or call it the pre-trial conference that we're expecting in the next exactly 30 minutes. And my next question comes to you, Counsel. Looking at the files, I have been at the registry, the For Other House registry, and I can tell you the volume of documents there is quite immense, and we only have 5 days. They have to do all that. At least they have been able to dispense some of the interlocutory applications that were made, and even dismissed one of the petitions. But is that quite sufficient?
Well, Njue, I agree with you that 14 days is not sufficient to hear and determine petitions and issues that are actually arising from the petitions that we file in court. In any event, even the previous judges, if you interrogate the sentiments of the retired Chief Justice Emeritus William Mutunga, he'd made mention that, in his own view, I think we need to have a constitutional reform in enlarging the time that we have in our constitution. 14 days cannot and will never be sufficient to address the concerns that we have as a country. But be that as it may, we have seen the invention of our judges. Remember, judges are actually expected to be Solomonic in the way they deal with the matters. And the directives that you're seeing from Anna Amadi, the registrar of the judiciary, these directives are actually informed by some wisdom, so that we can help in controlling the time that we use, or the timelines that are there. So that if you return back to the rulings that have also been made today, we have seen the admission of the office of the AG, or the Attorney General, as one of the parties. We have seen the admission of the Law Society of Kenya as an amicus, or rather, if you want, as a friend of the court. And one thing that is very interesting, if you read these rulings, is that the court has made mention that we shall only consider the brief, the amicus brief that has been written. So this is to mean that the Law Society of Kenya shall not be allowed to make oral admissions during the hearing of the case that has been filed challenging the declaration of William Samoei Ruto as the president-elect. Now, this in a sense should tell you this is a way of also saving on time. Remember, lawyers and pastors have one thing in common. They will tell you they will speak for 2 minutes. Then the 2 minutes become 20 and it becomes 1 hour. So in order for us to control, because you see judges also need to go and retire, they need to go and sleep, have some rest, so that they can come with a fresh mind to hear and also determine some of the issues that will be arising. If you read keenly through the petition that has been filed by the Right Honorable Raila Amolo Odinga, there is also the mention of his sought reliefs or prayers to be allowed to scrutinize some of the results from different polling stations, with the hope that he will get them in their favor and probably a declaration in his favor. So this should tell you. This should tell you that there is wisdom to determine some of these preliminary issues well in advance, because ultimately if you read the Elections Act, particularly under Section 84, it tells us that the court can actually direct the IBC to declare you the winner if, after a scrutiny or a retally, it is established that you actually won the elections, but there was an error during the declarations. So really, it is important that we have some of these preliminary issues decided before we get to the hearing of the main petition. So that at the main petition, there will be some discoveries that will be made at the interlocutory. And these discoveries at the interlocutory stage are the ones that are going to help the court in arriving at a just determination. Remember, the determination that should be made by the Supreme Court is not one that should be popular. Of course, the determination will either go in favor of Dr. William Samoei Ruto or will go in favor of the Right Honorable Raila Amolo Odinga. So whichever way, we will find about 6 million of us will be uncomfortable about the decision. And another 6 million plus will be very happy about the decision that will come from the Supreme Court. So what is important is not a popular decision. What is important is for the Supreme Court or the court to arrive at a just determination, having considered every single material that is placed before it. So that if you ask yourself, I mean, with the bundles of documents, with the so many participants that are in these proceedings, will the court really have sufficient time? I know for a fact that the judges have assistants who help them during research and drafting and all those things. But really, it is not sufficient from where I sit that a decision of this magnitude should be handled or should be decided within a span of 5 days.
Yes.
So moving forward, probably when we have an opportunity of suggesting some amendments in our constitution, and I saw it even in the failed BBI attempt, that there was a proposal to expand the timelines of hearing and determining the presidential petitions. Yes. So it's a wait and see of what the future has for us as a country.
And now, Doc, looking at still on the IEBC, of course, in 2017, NASA then said we are not going back to the ballot if we have IEBC and the commissioners that are there. We have had issues of quorum. Do you remember during the BBI case? It's something that was very prominent in the High Court, the Court of Appeal, and also at the Apex Court. Let me jump the gun. The Supreme Court, a lot of people are expecting, and Kenyans are expecting, that only two decisions, either to annul or affirm. And if we have to go back to the ballot, I don't know how that will play out, because despite the fact that we have a divided commission, we also have trust issues. And it is the only independent commission that we have in the country, Doc.
Yes, those are the Solomonic areas that the courts have to look into, because you see, in the long run, you need confidence of Kenyans on the commission. And if the commission is divided, then the confidence will go down. You'll just still see the split coming out into four, and when that split come out into four, it will then dent into the credibility of the process again. So there will need to be a lot of Solomonic wisdom in the decision that the Supreme Court will have to come up with. And that's why I say that the decision will have to be one that looks at the peace and justice of today and the threats of tomorrow.
And still on the same, do you believe that we need to relook at the commission? Because we cannot only be having challenges when it comes to the presidential election. Absolutely, and I strongly agree with that. As a person who also was an observer within the bombers, there are many issues that I saw that need to be looked at in the commission. Some of them, what we are seeing mainly are constitutional. There are a lot of operational issues that need to be dealt with at the corporate level. For example, communication is a big problem for that commission. Right from beyond what you were seeing on the television, even how they were interacting with the journalists, you could see a lot of gaps that needed to be dealt with. And I think that this need for a lot of relook of the legal mechanism around it,
and also the operational mechanism around the commission, if it really has to deliver its mandate objectively. Otherwise, we are still likely to see similar things happening. And if we are to go into an election, a rerun with the same, if we are to go into a rerun with the same commission as it is, then we are likely to have a lot of problems, because some of the parties will not want to accept it, and those are not the kind of things that we want to have. As we need a judgment that will bring confidence on Kenyans on the election, and also apart from that, apart from bringing confidence on Kenyans on the judges, a judgment that will also ensure that Kenyans get justice. If somebody won the election, he's given his win, and those who lost the election can also accept that they lost the election. So that relook will be very important to be undertaken by all those who will be involved.
Council, let me bring in your comments on this, because at the end of the day, if we have to go to the ballot, of course, we have to also look on the other side, the IEBC. There has been so many questions that have been raised in regards to their operation, and also the public trust has been quite eroded. How do we go to the ballot, or we do expect, just exactly as you said, as you can see on your, just a minute, Council, as you can see on your screen, we have Professor George Wajakoya, who was also in the presidential race, but now wearing a different tag and wig, for that matter, as a lawyer who, despite his campaigns and actually also not even being one of the two, he has also been enjoined in the same. Council.
Yeah, I mean, it is something that is it's very interesting to see, because he's trying to show something. He's trying to show that I was into this race as a politician, but above that, I also believe in the law, and I want to ensure that my opinion as a legal expert is also expressed in this. So I think it is something that is very good, and we are yet to see how he will synchronize his political thought with his legal theory.
And Wamboi, if we have to go to the ballot, we still have IEBC, which is mandated by law to do that. But unfortunately, as I said, public confidence has been eroded. The numerous cases that have been filed against IEBC, a divided commission. Well, do we need the Solomonic advice from the 7 Apex Court judges so that we may know exactly what we do? Or do we have what, a caretaker committee if we have to go for a rerun?
Well, the IEBC is a constitutional body. It's a commission that is created by the Constitution with some autonomy. It has some independence. And when you look at the commissioners, you must look at them differently from an employee, because they enjoy some constitutional protection. So that if you want to remove them or disturb their tenure in office, then there is an elaborate legal process that the law has put in place to ensure that they enjoy the protection. Remember, even after we are done with Chebukati, who should be retiring sometime in the month of January 2023, we'll have some other commissioners or other chairpersons who are not going to sit well with other individuals. So really, there must be some level of respect that we accord to their office, not necessarily even to their individuality. But even saying that, of course, I remain conscious to the fact that there has been an open display of disagreement between the commissioners. And I know too well that the Constitution also provides for mechanisms. Other than even running to courts, we have mechanisms that are put in place to ensure that we promote reconciliation, negotiations. So this is the time that our religious leaders should be taking the front row seat, so that they can broker an agreement between some of these the commissioners that are fighting, or we are seeing them to be fighting. So really, what is important
And as you can see, just a minute, Wamboi, as you can see, those are some of the lawyers that will be battling it out in the Supreme battle today. I've been seeing Senior Counsel Philip Murgol, and we have seen, yes, he's the one who's standing slightly a couple of meters just outside the court. And also, as you can see on your left is a ceremonial hall at the Supreme Court that will play host to the case. And 10-15 minutes ago, it wasn't as busy as it is now. So we're expecting the judges to keep their time at exactly 11 as they had talked about also in the presser and also in the press release that they just issued yesterday. Allow me now to bring in yet another constitutional lawyer, Henry Kurauka. Karibu sana, Counsel.
Thank you very much.
In a nutshell, we've been talking about the Solomonic decision that we expect in just 5 days, and we haven't started the case yet. I would like to pick your I'll pick your mind on that as we rectify that on how all these things we are expecting it to pan out. And Wamboi was touching on what we can do as a country, because if at all the Apex Court decides that we will have to go back to the ballot, we don't have a choice. We have to go back to the ballot. But unfortunately, on the other hand, we still have a lot of housekeeping to do at the IEBC. Counsel, you had not finished your sentiments on what we are supposed to do as a country. Are we supposed to get maybe a caretaker committee? Because we have to do that as enshrined in law in 60 days. We cannot sort out all the IEBC mess in that time and hold a rerun in that time as well.
And I will still insist that I know it is not constitutionally possible to have a caretaker commission. Mm-hmm. Remember, and I have made mention of this, the commission is a creature of the Constitution. It borrows its power and authority from the Constitution. So if you want to come up with a caretaker committee, you cannot do that without amending the Constitution as we know of it today. Mm-hmm. So my only emphasis is that we need to have some brokers of peace, so that our religious leaders, we have our political leaders, and we have, we have ambassadors, we have people from all walks of life. You remember it took the hand of Kofi Annan in the year 2007 to just come and at least help us in reconciling ourselves. So I think most importantly we need to reflect on the importance of our office and the importance of what we do in our offices in the future, so that we can just get away, or we can just refuse or decline the distractions that we are seeing from this petty politics that we have been seeing. Yes, but yeah. I think that is the only thing that moving forward we can help in salvaging the situation. Otherwise we'll have just an anarchy or some level of lawlessness moving forward up until when some of these three commissioners who should be retiring in January are out of office, which is not constitutionally possible, because in the event that we have a rerun, we have a repeat election, it should be done within 60 days, and 60 days will not take us to January. So we'll still have the 7 commissioners, uncomfortable as they are finding themselves, still in the same office.
Okay, Kurauka, your sentiments on the same.
Thank you very much. My views are as follows. I do expect only 2 outcomes from the Supreme Court. The first outcome is validation of the elections, in which Dr. Ruto will be sworn in on the 13th of September. The other outcome that we expect is invalidation of the elections. Once that is done, we must have fresh elections within 60 days. Now, our Constitution does not limit the number of elections that our Supreme Court can invalidate. So it can go on and on and on until 2027.
That's an interesting way to look at it, because you're talking about if we go for a repeat election and somebody raises the same petition at the Apex Court, we can just keep on.
It's a separate election. It must comply with the law. And the Constitution allows the Supreme Court to do what it is supposed to do. When the petitions were filed, in my view, President-elect status was frozen, because he cannot be sworn in until the Apex Court makes a decision. On the issue of our people, the Kenyans, we have now matured. We are not trying to fight each other over elections. I'm so happy that we have had very peaceful elections. And my appeal is to religious leaders, stakeholders, the people of Kenya to uphold the peace we have enjoyed. Because at the end of the day, we have a country that belongs to each one of us. Now, to our leaders, we have many leaders who have been elected. Kindly uphold the core values. Act in good faith for the interest of Kenyans, and we shall have a very peaceful country, whichever way the judges rule. And we have a lot of confidence with our judges. All of them are men and women of great integrity and legal minds. Finally, I would like to say that the problem in Africa is that Africa is full of graveyard of wonderful laws, wonderful constitutions. But when it comes to leadership, we have issues with many leaders, and that's where the confidence has really gone down, whereby leaders do not want to act in good faith and for the interest of the common man, so that we ensure cost of living is down and leaders are there to core values are integrity, honest, corruption-free, and so on. Therefore, as a constitutional lawyer, I wish to call upon Kenyans to be peaceful, to accept whatever results comes from the Supreme Court, because it is the final arbiter in this dispute. As to the merits of the petitions, we cannot discuss now, but we have faith in our Supreme Court. Thank you.
And Doc, back to you. Council Kurauka has talked about how we have very good laws, but unfortunately we have dumped them in a graveyard. But away from that, he has also mentioned about we have always mentioned about the Solomonic, the decision that we are waiting by the 7 judges, Martha Koome, Philomena Mwilu, Smokin Wanjala, Mohammed, Ibrahim, Joaquin Rungu, and also the latest to join the fray, that is William Ouko. But it is the first time that the CJ is having this petition on the bench. It is also the first time for William Ouko. And it is now constituted 7 judges as opposed to what we had in 2017. What level of sharpness should they be? Because this is quite a unique petition.
Yes, I think that the beautiful thing is that these are people who have had experience within the judiciary, and I'm sure that they have had a glimpse of cases around petitions, not necessarily of presidential nature, but maybe of other caliber. And so they have served previously within different locations, different positions in the judiciary. So this really, that wealth of experience is going to be of significance for them as they make these judgments. And the beautiful thing about this is that I think for the first time you're having a lot of these. Of course, the petitions even previously were in the public opinion, but in the public domain. But you are seeing a lot of affidavits, being in public domain, and the court of public opinion are also making their own judgments. So there's a lot of things that the judges have to look for. So in as much as they're going to look at, we are talking about the Solomonic wisdom, yes, but then it's just because the law is also there that gives them the framework upon which to make certain decisions. But then the law is not like 1 + 1 is 4. Okay, it's not like mathematics that is very definitive. It will give you the framework, but then you have to make decision within that framework so that it becomes justifiable. And so it is within those that it is out of that indefinite that then brings in the idea of judges, the need for judges to look at situations and come up with the Solomonic judgments at any given time. And for me, I still believe that this petition at this time is not just for today. And we need to look at it beyond a win or a loss of an election and see the possible threats that our country faces for the future. Because we can be so focused on today until we forget tomorrow. And then when tomorrow comes, we wish that we should have looked at this before.
Council, Doc is talking about this being quite a Solomonic decision that they have to make. And not only will it cater for today, will also cater for tomorrow. Looking at the current jurisprudence, we had a big one in 2017 when the elections were annulled. We also had a big one when the BBI also went to the drain. Now we have even judges and observers from outside, and the 2017 decision was hailed by many countries as quite a decision, and a bold one for that matter. Now we are in the same position again. The decision of these judges, what does it speak of the current jurisprudence that we have in the country based on what we've had in the last couple of, let's say even in the last 2 years, because we've had the BBI, which also went all the way to the apex court. Now we also have an election petition, actually many petitions for that matter.
Well, Njue, I agree with Daktari here that indeed the task that lies ahead of the 7 Supreme Court judges is quite, it's a big task that should not only look at the present, but should have a keen look at the future. Remember, the Supreme Court is just a unique court that was formed after we promulgated the Constitution. Previously, the Court of Appeal was the highest court on this land. But the Supreme Court, if you read the Supreme Court Act, it has some special jurisdiction or objectives. It has some objectives that it must fulfill every time it makes a decision on any issue. Number one, it must ensure that there is indigenous growth of our law. That, of course, focuses also on our past. It looks at our history as a country. So that any decision that the Supreme Court comes up with must first be informed by our history as a country. And perhaps when you had the opportunity of discussing, the fall of the BBI decision, you saw there was so much emphasis on the history of this country. And this informed to a larger extent why the Supreme Court found the BBI, or rather the Constitutional Amendment Bill of the year 2020 to be unconstitutional. So really, it is important that when we decide some of these questions, and some of the most important questions before the Supreme Court, if you want to even summarize them, does the decision that leads to the declaration of one as the president-elect have to be a decision that is made by the commissioners, or rather it has to be a decision that is only made by Chebukati or the chair of the commission, and then the chair of the commission, after making the decision alone, makes then the declaration alone. So really, these are some of the very important questions, because moving forward, we will still have the commission.
Yes, of course.
We will not have Chebukati, but we will have the commission.
We have the commission, and it's the only independent one for that matter. Indeed, and we were going to be touching on the same after we come back, but first of all, let's have that break. But looking at your screen, you can see that the apex court is just a few minutes shy of 11 a.m. And of course, we will be getting back to that court a little bit later as soon as those judges get into that. Remember, today is pre-trial conference. We'll be back in a minute.
To get Change Your Thinking Skiza tune, dial *811*961#.
When you change the quality of your thinking, you change the quality of your life. sometimes instantly. Just as positive words can make someone calm, smile or laugh, your thoughts will react to the world in real time. So, change the quality of your thinking.
Dial star 811 star 961 hash. Star 811 star 961 hash.
Welcome back. This is Kenya Decides, and today we are looking at the Supreme battle that we expect at the Supreme Court any moment from now, because it's just a minute to 11. We're expecting the 7 judges of the Apex Court to be landing at the court that is at the domicile at the Milimani Law Courts. And on one corner, the presidential petition, a petitioner seeking to have that presidential election annulled. That is on the blue corner, that is the Raila Odinga and the Azimio Brigade. But on the other hand, on the president-elect side, they say that the elections were free, fair, credible, and verifiable as demanded by court in the year 2017. When you do remember, we had to go back to the ballot. And I have this panel of experts trying to look at the things in a more fashionable and more easier, because we will be having a lot of jargons flying here and there, and we are trying to put these things a little bit into perspective. I have Dr. Churchill Saoke, who is a leadership and governance expert and also a lecturer at the Jomo Kenyatta University of Agriculture and Technology. Wamboi Shadrack is also a constitutional lawyer, same as Henry Kurauka, who is also a constitutional lawyer. And before the break, we were looking at the jurisprudence in Kenya. We had a landmark judgment in 2017, hailed by many countries as well. We had to go back to the ballot peacefully, and we did that. Now we had the BBI that went to the Apex Court, and we did that. Now we also have another one. But in this year, Henry, you will agree with me, it's quite different from 2017.
Correct.
This one is quite heavy, if you ask me. We didn't have a divided commission back then. We have a divided commission now. We have so many petitions. Of course, we expect some to be consolidated during the pre-trial hearing today. The level of jurisprudence that this country is, and especially in these landmark decisions, your sentiments?
Yes, we have to give credit to Kenyans because of the 2010 Constitution. We are actually light years ahead of our neighbors. For instance, in Tanzania, the decision of IBC, or rather the electoral body, is final. No court can challenge their decision. So we are light years ahead. Kenya appears to be the first country in the world to annul presidential elections. And our Supreme Court decisions have been cited all over the world. Today, we have, I understand, 11 judges, foreign judges, who have come to follow the proceedings. And that credit goes to Kenyans. We did so because previously there were a lot of challenges in rendering a credible, a fair, and transparent elections. You remember the times of Mulolongo and so on. Mm-hmm. So to cure that, the Supreme Court was brought in as a key organ in electoral processes, so that if INBC does not follow the law, then decisions will be amenable to judicial intervention. Mm. And not only these presidential elections, we have so many other petitions over other seats that are being challenged across the country. So we need to commend our courts, our citizens, our government for even enabling our Supreme Court to do its work. Thank you.
Yeah, and Wamboi, I'll be coming to you because we have looked at the timelines. Mm-hmm. If at all, President-elect William Ruto, the court affirms his election, he still have another hurdle. At the same court, you do remember, there's a lawyer Kibe, has filed a petition to block his swearing in. Okay, marinate on that. Let me go to Doc. Looking at the election cycle in Kenya, we have said that election matters in Kenya are a matter of life and death, which it shouldn't be like that. And unfortunately, we have lost a lot of IEBC staffers just because of the election. And 2022 was no exception. We've had cases of disappearing, harassment. At the bombers, they say that some commissioners, including the CEO, had to be taken to seek medical attention just to see how the level of life and death that elections are in Kenya.
Yes, that is something that is very evident, and I think it's one thing that we have to say it's pretty unfortunate because
as you can see, just a minute, Doc, people are, yes, indeed, we are almost now crossing over because as you can see, the people have started streaming in. The judges, they are led by William Ouko, a new entrant to the Apex Court. We also have Mohammed Ibrahim. We can see Njoki Ndongo. Of course, the CJ, Martha Koome, will be having or sitting in her first presidential petition. Her deputy is there. Let's first of all listen in.
Good morning, ladies and gentlemen, and welcome to Supreme Court of Kenya for the pre-trial conference of the presidential election petition. The Honorable Chief Justice and the President of the Supreme Court of Kenya shall preside over the session. Pre-trial conference number 1 is presidential election petition number E001 of 2022, John Njoroge Kamau versus Wafula Chebukati and others. Counsels, kindly introduce yourselves to court. You're welcome.
Madam Chief Justice, Honorable Madam Deputy Chief Justice. Thank you. Can I be heard? I'm sorry, I'm not used to such complicated things.
We can hear you, Counsel.
Madam Chief Justice, Madam Deputy Chief Justice, distinguished judges of the Supreme Court, my name is John Mohammed. I appear with Mrs. Wambugu for the petitioner in this matter. That's an EP election petition, presidential petition number 001 of 2022. Would you request the council? Would you want the other councils to introduce themselves, or I think it might be an easier way.
If you are able to introduce them.
Yes, I am.
That is the practice of the court, that the senior counsel introduces the others.
Madam Chief Justice, there are senior counsels even in their side, so I will do the best that I can. My learned friend, Mr. Gumbo, appears for the first respondent. My learned friend, Mr. Kamau Karori, appears for the fourth respondent. I'm not sure on who appears. There was Ms. Kithure Kindiki are on record for the second and the third respondents, because the interested parties were struck out with the ruling that was delivered this morning. So that is the position vis-a-vis this petition.
Milady and members of the court, my name is Githu Muigai, Senior Counsel. I appear for Mr. Wafula Chebukati, Chairman of IEBC. Mr. Eric Gumbo and Mr. Kamau Karori appear for IEBC.
May it please you, Chief Justice, your leaderships, my lord, I appear together with my learned friend, Professor Kindiki, and learned senior counsel Kioko Kilukumi, And those are the 3 slots we have been allocated for the 8 petitions.
I think you are allocated 4.
Yes, for the 8 petitions. So that will be the constant theme in representation for now the 3rd respondent.
You are allocated 3 council for the 9th respondents.
Very well.
Yes.
At least we have 1 more who will be joining us. Thank you, Chief Justice.
And for the record purpose, because we are recording the proceedings, Senior Counsel Friend Gatia, you didn't say your name. We know you, but the system may not.
Chief Justice, thank you very much.
Put the mic.
My name is Ngatia Frederick. It's my joy and pleasure to be the team leader for the 3rd respondent.
Thank you. That is all about the appearances.
My Lady, the Chief Justice and members of the court, I've just been alerted by a senior counsel who is locked out, who should be in these proceedings. Senior Counsel Paul Mwite and Counsel Ali Mansour for the IBC. I think it's a matter which is live before the court to make a determination whether they could be had. But they have filed papers and they ought to be left at least allowed in.
Senior Counsel, they have not been disallowed. They have not been disallowed. The commissioners to IBC have not been disallowed. They were, as respondents, they are entitled to be present with their lawyers.
Yeah, my lady, probably I'm not understood. I've not been understood by the court. There are 2 factions of the IBC, so to speak.
Both factions are allowed
Much obliged.
participate in the proceedings
Much obliged.
with their lawyers.
So I think Senior Counsel Paul Mwite should be allowed in.
Yes.
Senior Counsel Ali Mansour.
Yes.
They just told me they are not been allowed to come in.
That I don't know who read that ruling. It must be upside down, because we allowed the commissioners to participate with their lawyers. They can be called in. Any other appearance? Yes. Yes, have the petitioners introduced themselves? You know, we have petition number 1, petition number 2, 3, 4, 5. Petition number 6 was struck out.
With your kind permission, Your Ladyship and members of the court, in petition number 2, presidential petition number 2 of 2022, I am Paul Nyamodi. I appear for the petitioners, together with my learned colleague, Mr. Tom Masharia and Ms. Njue Mboshe.
Petition number 3.
My Lady, the President of the Court and members of the Court, in this petition, my name is James Orengo, and I appear together with the Senior Counsel Philip Murgor, Paul Mwangi, Jackson Awele, Velma Auma for respondent number 11.
My lords and my ladies, for petition number 3, Otieno Willis, I do appear for the petitioners. Maybe there was a mix-up in the numbers. For petition 3, it's Willis Otieno for the petitioners, appearing with Nelson Osiemo.
May it please you, Madam Chief Justice and the members of the court, my name is Githu Muigai, Senior Counsel. In that matter, I appear for Mr. Wafula Chebukati, the chairman of IEBC, assisted by Mr. Eric Gumbo. I also appear for IEBC, assisted by Mr. Kamau Karori, Senior Counsel.
Paul Muite, Chief Justice, Deputy Chief Justice, Your Ladyship, my lords, in petition number 1, I am instructed by the Independent Electoral and Boundaries Commission to appear for it on the basis of a resolution by 4 commissioners, and I appear with my colleague Isa Mansour. Thank you.
Thank you.
Madam Chief Justice, maybe this would be a good time to give directions on how we should proceed on this rather irritating and irrelevant matter that has been raised, when it is quite clear that the record speaks for itself. My learned friends filed appearance way before the said resolutions, but I do not wish to go into the evidence without your permission and without your directions, whether we do it now or later.
We'll do it later.
I am most obliged.
Yes, if we have recorded all the appearances. Okay, let's finish with the appearances.
My Lady, Madam Chief Justice, the President of the Supreme Court, and Madam Lady Deputy Chief Justice, the Deputy President of the Court, and the members of the court. My name is Dewanjiru. I appear together with Gerard Mituga in petition number 5. Sorry, my lady, petition number 4, David Kariuki Ngari.
Thank you.
My Lady, Madam Chief Justice, and the members of the court, my name is Jotham Marwa. I appear for the 4th respondent in petition number 2. Thank you.
My Lady, Chief Justice, and members of the court, my name is Apple Lomboya. I appear for the 3rd respondent in petition number 2.
Thank you.
My Lady, the President of the Court and members of the Court, in petition number 4, I appear together with Senior Counsel Philip Morgor, my learned friend Paul Mwangi, Jackson Awele, Velma Maumo, and my name is James Orengo.
Thank you.
For the 10th respondent.
My Lady, the Chief Justice and members of the court, I'm Jenga Jeremy in petition number 5. I appear for the 7th respondent.
May it please my lords, my name is Gordon Ugola. I appear for the 8th respondent in petition number 5, together with Mr. Elvis Nanda and Ouma Ochola.
My Lady, the President of the Court and members of the Court, in petition number 5 of 2022, the appearances for the 2 petitioners, first and second petitioners, the appearances as follows. Senior Counsel Philip Murgor, Mr. Paul Mwangi, Mr. Jackson Awele, Ms. Velma Maumo, and James Orengo.
Okay. I guess now we are through with the appearances.
My Lady, if it may please the court, my name is Emmanuel Bitter. I appear for the Attorney General, that is in petition number E03, the interested party, and in E07, the 9th respondent.
Your Ladyship, the Chief Justice and President of the Supreme Court, the Deputy Chief Justice and the Court, I appear in petition number E007 for the 2nd, 3rd, and 4th petitioners. Mr. Okio Mtata appears in person for the first petitioner, just for the record.
A very good morning, my Lady Chief Justice.
Did you record your name for purposes of the answered?
Yes, Your Ladyship?
Your name.
Oh, sorry. Professor Tom Ojenda, Senior Counsel.
Thank you.
Thank you. Kisumu County. Thank you.
A very good morning, my Lady Chief Justice, President of the Court, Deputy Chief Justice, honorable members of the Court. My name is Stephen Mwenesi, Advocate. I appear in petition E005 alongside with the President of the Law Society, Eric Theuri, for the Law Society of Kenya's amicus.
And my lady, my name is Ochiel Dudley. It's my pleasure to appear before you again, this time for the International Commission of Jurists as amicus curiae. I appear alongside Ms. Anne Shikongige, who is in the adjoining court. Thank you, my lady.
My Lady, the Chief Justice and Honorable Judges of the Supreme Court, my name is Charles Kanjama, SC. I appear for 3 amici curiae in petition number 5. That is, I appear for John Wadubengo, Dr. Joseph Sevilla, and Martin Mirero.
May it please you.
My name is Chief Justice and other members of the court. My name is. Oh, sorry. Let me repeat. May it please you, my lady, the Chief Justice and other members of the court. My name is Kibe Mongai Advocate. I'm appearing in petition number E008 alongside Ms. Wairimo Keru.
Thank you.
May it please you, my lady.
My lady, there used to be a rule about seniority. I have been stood down twice.
Yes.
Maybe I should go.
It is still there.
I appreciate my lady's protection. My lady, my name is Gedhu Muigai, Senior Counsel, and I appear for Mr. Wafula Chebukati, supported by Mr. Eric Gumbo. And I appear for IEBC, supported by Mr. Kamau Karori and Mr. Mohat Jomane and Mr. Tito Tiago.
Yes, this is the third time you are telling us that, as Professor.
Okay, my lady, I thought we would need to do that in every matter, but I'm guided by you now, and I yield the floor to my learned colleague.
Okay.
Madam Chief Justice and the honorable members of the court, my name is Jotha Marua once again. I appear for the 6th respondent in petition number 5. We had been under the impression that we are recorded on every matter. Thank you.
Thank you.
Your Ladyship and members of the court, my name is Apollo Mboya. With respect to petition number 4, I appear for the 3rd respondent. With respect to petition number 5, I appear for the 5th respondent. And lastly, with respect to petition number 7, I appear for the 3rd respondent. Thank you.
Thank you.
Madam Chief Justice, permit me to introduce Mr. Morara in petition number 4 for the petitioners. Here is seated in court number 1. I erroneously left out his name. Mr. Morara.
Thank you. I think we now have all the appearances. You will allow me, on behalf of my brother and sister judges of the Supreme Court, to first of all say a very good morning to all of you, and also to welcome all of you to these proceedings. I wish to recognize our distinguished guests who have joined us this morning, recognizing the Honorable Retired Chief Justice Othman Chande and your entire delegation of eminent African jurists who have come to observe these proceedings. You're very welcome. I wish to also recognize the parties who are present, the petitioners, the respondents, their friends and supporters who are watching us online. Unfortunately, due to constrained space that we are operating from, we could not accommodate very many people. You can all see we are all required to observe the COVID-19 protocols. We also have to be mindful of security and the constrained time, and therefore we were forced to limit the number of the counsel who can appear at any given time. But parties are free and at liberty to have as many counsel as they could. We'll try to accommodate as many as we can in the speed of a room, court number 1, where they can follow the proceedings and continue assisting counsel who are in the plenary. We thank the media also for coming to stream the proceedings online to assist Kenyans and all people from all over the world who are watching and following these proceedings. across Africa and across the world. We specifically want to thank the observers who have come to be part of this process to attest that we are all guided by the rule of law, constitutionalism, values that we all share across Africa and indeed in the Commonwealth and all over the world, and also to express the judicial solidarity for us, which is a core emblem which cuts across the border as we attempt to develop our jurisprudence and work together in the spirit of bilateralism and regionalism. We therefore welcome you to Kenya to these proceedings. Today, Council and parties, we are here for the pre-trial of the election petitions that were filed before us. As you are aware, 9 petitions were filed, and we received 25 preliminary issues in form of interlocutory applications. We have been able to dispose of all those preliminary issues and delivered rulings online, which I believe you are still reading and internalizing. After we dealt with the preliminaries, 2 petitions were struck out. Petition number E006 and petition number E009 was struck out, and the rulings were delivered together with the media summary showing the reasons why they were struck out. So we are left with 7 petitions, and the court has considered the 7 petitions which emanate from the same presidential election, which was held on the 9th of August 2022. So upon perusing and considering the issues raised in the following petitions, E001, E002, E003, E004, E005, E007, and E008 of 2022, and the respondents thereto, we find that all those petitions raise similar issues and seek similar orders. Therefore, we order that petitions numbers E001, 2, 3, 4, 5, 7, and 8 of 2022 be and are hereby consolidated with petition number E005 of 2022, which is designated as the RIND presidential election petition for 2022. The parties will therefore be, the ending of the matter will therefore read as Raila Odinga and Martha Karua will be the first petitioners. John Joroge Kamau will be the second petitioner. Youth Advocacy Africa and Peter Kilika will be the third petitioner. Kerif Karifa, John Josewe, Ruth Mumbi, Grace Kamau, David Kariuki will be the fourth petitioner. Okia Umtata Okoiti, Nyakina Wycliffe Gisebe, Victor Okuna, John Maina will be the sixth petitioner. Julia Nyokabi Chege, Joseph Mutua Ndonga, Simon Mwaura Njenga will be the seventh petitioner. The respondents will be William Ruto and Rigathi Gachagua, the first and second respondents. IBC will be the third respondent. Then Mr. Wafula Chebukati, fourth respondent. Juliana Cherera, fifth respondent. Irene Masiti, sixth respondent. Justice Nyangaya, seventh respondent. Francis Wanderi, eighth respondent. Professor Gurie, ninth respondent. Boya Moru, 10th respondent. And the Attorney General will be the 11th respondent. From the rulings that we delivered, we have admitted Law Society of Kenya as amicus curiae or amici curiae with ICJ, Mr. John Warubengo, Dr. Joseph Savila, and Martin Milero. That is the order of the court for the consolidation of the matter. So the other issue that we are going to deal with this morning upon consolidation of the matter is to settle the issues for determination. The court, having considered the printings that were filed, the submissions, and all the documents that were filed, we have framed 9 issues that have been shared with you by now, I believe, but I'll read them out. The first issue is whether the technology deployed by IBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Issue number 2, whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IBC public portal. Issue number 3, whether there was a difference between Forms 34As uploaded on the IBC public portal and Forms 34As received at the National Tallying Center and Forms 34As issued to the agents at the polling stations. Issue number 4, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheriba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. Number 5, whether there were unexplained discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 6, whether the IEBC carried out the verification, tallying, and declaration of results in accordance with the provisions of Article 138(3)(c) and 138(10) of the Constitution. Issue number 7, whether the declared president-elect attained 50% plus 1 vote of the votes cast in accordance with Article 138(4) of the Constitution. And number 8, whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. And finally, what reliefs and orders can this court grant or issue? Those were the issues that the court has come up with. Perhaps then we can proceed to the next area. Council present and parties, considering the constitutional time frame for determining the consolidated presidential election petition and the nature of the issues raised, as well as the COVID-19 pandemic, we have limited the number of advocates who can sit in the plenary as per the schedule that was shared with you this morning by the registrar of the court. For further clarity, been asked to clarify that parties have a right to representation of as many lawyers as they wish. The only reason we cannot accommodate everybody here is because of the limited space. We are still in the COVID-19 protocol that requires social distancing, and also because of security. However, on account of all these considerations, we have facilitated additional advocates to sit in courtroom number 1, where the proceedings will be streamed live. I will seek your indulgence on behalf of my brother and sister judges and cooperation in this regard. We have also shared a time allocation that is allocated to each one of you. I believe you have been given a copy of the time allocation schedule. Things are streaming online. If you can check, maybe it has come, but I can read it for you. When we will start the hearing tomorrow, the main petitioner, that is petition number E005 of 2022, Raila Odinga and Martha Karua, we have allocated them 3 hours. The supporting petitioners, being petition number E001 of 2022, John Joroge Kamau, we have allocated that supporting petitioner 30 minutes. Petition number E002 of 2022, Youth Advocacy Africa and Peter Kirika, we have allocated 30 minutes. Petition number E003 of 2022, Kerif Karifa and others, 30 minutes. Petition number E004 of 2022, David Kariuki Ngari, 30 minutes. Petition number E007 of 2022, Okia Omtata Okoiti and others, 30 minutes. Petition number E008 of 2022, Juria Nyokabi and others, we have allocated them 30 minutes. It is hoped that that will be the time allocation for tomorrow, and when we proceed to the hearing of the we've also looked at the responses by some respondents, namely Juliana Cherela, Irene Masit, Justus Nyangaya, and Francis Wanderi, who appear to be supporting the petition. These 4 respondents have been allocated 1 hour to share among themselves. That gives to that 15 minutes each if they are represented by different council. Then parties in opposition to the petitions, we have identified IBC together with the chairman, Wafula Chebukati, and we have allocated them 3 hours to share. William Ruto and Rigathi Gachagua, they have been given 3 hours. The Attorney General will be given 30 minutes to respond. According to the rulings that we have delivered, we admitted 3 amici curiae. They will not be given time to make oral submissions. According to the rules of this court, we will rely on their briefs, which are on record, unless the bench wishes to raise an issue for clarification by them. That will take us now the second day of the hearing. We are hoping the third day, which is Friday, we will hear a rejoinder. We'll give the main petitioner in petition number E005 of 2022, Raila Odinga and Martha Karua, 1 hour to respond. Petition number 001 of 2022, John Joroge, will have 15 minutes. Petition number E002 of 2022, Youth Advocacy Africa, 15 minutes. Petition number E003 of 2022, 15 minutes. Petition number E004 of 2022, 15 minutes. And petition number E007 of 2022, 15 minutes. And petition number E006 will also have 15 minutes. As you will also have noticed, we have given a comprehensive ruling on the applications that were filed seeking discovery, various discovery and scrutiny. According to the order that has been issued, we are expecting a report that will be tabled before this court for consideration by Thursday afternoon. And if there will be issues arising from that report, we have agreed to give the main petitioner 30 minutes to respond. And because they filed an application for discovery, so was Youth Advocacy Africa and Mr. Kerif, they also filed an application for discovery. According to the issues that they were raising, the Youth Advocacy will be given 20 minutes, and Kerif, who was seeking one issue, will be given 10 minutes. The IBC will be given 30 minutes, and William Ruto and Rigathi Gachagua will also be given 30 minutes to respond to the report that will be filed if there will be issues arising which they will wish to respond to. That is the time allocation. Due to the time constraints that we have to determine these election petitions within 14 days, we will appreciate also the filing was tight within 7 days. This is dealing with information or evidence from all over the country. The framers of our constitution decided that they will give 14 days. It has been done before, and we hope to do it also this time. But we will also seek your indulgence when you are allocated your time, you will adhere to the time. We also developed some ground rules as a court where we are requesting that parties and advocates observe punctuality, the time that is indicated for us to start the proceedings, and the time allocated to them on the screen. We will also, this is an old practice, that we will continue to be respectful of the court, our personnel, and also to respect each other, adhering to the rules of this court. We also are obliged to state that we expect parties to conduct themselves with decorum to preserve the dignity of the court and the proceedings, while bearing in mind the provisions of Section 28 of the Supreme Court Act. We are also reminding ourselves that these are judicial proceedings being conducted in court and therefore discussing the merits of the case by the parties or counsel outside the court is not permitted. We still have the power under Section 28 of the Supreme Court Act to cite such parties who are in violation of the provision of the law. We also like to remind you that courtesy must be observed at all the time. The court will not tolerate offensive language. We like to repeat about the time allocated due to the time constraints. Once a party has exhausted the allocated time, the microphone will be switched off. We also wish to state that if there is time that is unspent by the council, the time belongs to court, so we will not allow anybody to donate, but revert it to the court for the court to share it out according to the court's generosity or lack of it. Due to the limited timelines, there will be no extension of time, so please let no one ask for extension of time. We are dealing with the submissions that have already been filed. We have been painstakingly reading those submissions. Therefore, we wish parties to just focus on the key issues that they would like to highlight. Parties are therefore urged to focus on the pertinent points of their case to save on time. We always like to remind parties cell phones must be switched off or on silent mode. During the hearing, unnecessary movement or disruption when the court is in session is discouraged. However, parties or counsel or even the bench are however permitted to take care of breaks during proceedings as the need may arise without disrupting the continuity of the submissions. And during these individual breaks, the proceedings will proceed. Even if I want to walk out, don't think the proceedings have stopped. They will proceed. The media present, we have already issued the media guidelines that must be observed all the time. Given the immense public interest in the proceedings, we have allowed media houses to run live broadcasts to enable Kenyans to follow the process from any part of the country and even beyond. We urge members of the public to follow the court proceedings from the comfort of their homes or offices through their television and stream broadcasts without the need of coming to court physically. This is particularly informed by the reality that due to the limited space within the court premises, we can only accommodate a limited number of persons to attend the proceedings in person. Consequently, we have restricted physical access to the court premises only to the persons who have been accredited as parties, counsel, or court personnel. We will also urge the counsel, when you're making your submissions, any references made to the material. You can see the voluminous nature of the files. They are still in our chambers. Please, we ask you to specify the bundle and the page that you'll be referring to for ease of reference. If there is any electronic presentation to be made, we would kindly request that it is provided to the registrar of the court 30 minutes before the commencement of the day's hearing. As I have said before, court number 1 has been prepared as a spillover room to accommodate parties and the advocates. We are also reminded by the Ministry of Health to continue reminding ourselves of the COVID-19 protocols and regulations which will apply in the course of the proceedings. We urge parties to cooperate and comply with these directions. I think that is all from the court.
Chief Justice, Deputy Chief Justice, Your Ladyship, my lords, judges of the Supreme Court, I think there is one matter, Chief Justice, there is one issue that was raised by my colleague, Professor Githu Muigai, regarding the correct team of lawyers legitimately representing the Independent Electoral and Boundaries Commission. This honorable court is aware that there is an application which was filed, I believe, fairly late last night and was responded to on that very issue. And I think in order to save time, I would suggest that perhaps the court considers that issue and gives directions in a ruling. My colleague, Professor Githu Muigai, and my good friend Karoli Kamau have filed a set of pleadings on behalf of the Commission. Issa Mansour has filed a set of pleadings on behalf of the Commission. As far as I am concerned with Issa, as I indicated, we rely on a resolution by 4 of the 7 commissioners. We have stated in our pleadings that we are legitimately representing the Commission. Our colleagues have filed the pleadings on the basis of instructions, I believe, by the CEO, who we say the CEO implements instructions from the Commission. The Commission is a corporate entity. In the absence of consensus, decisions are by majority. But because all these things are actually in the pleadings filed, all I'm pleading is that this honorable court considers those pleadings and gives its directions or ruling so that tomorrow we are able to move on without wasting the time of this honorable court. I thank you.
May it please you, Madam Chief Justice and the honorable members of the court, I would like to set the record straight. IEBC filed an application on the 29th of August 2022 seeking to strike out pleadings that were purported to have been filed by one Issa Mansour. That application is pending. We take the view, 2 reasons if we need to make the argument. First of all, we have a notice of appointment of advocates that predates the entry of Isam and Sue. Best civil practice would have required, if a legitimate change of advocates was to be made, for a notice of change of advocates to be filed. No such action was filed by what I consider a very, very competent firm of advocates. So in our view, there must have been collateral purpose. Secondly, it is not the work of the commissioners of IEBC, whether in majority or in minority, to procure any services. That flies totally in the face of the procurement law in this country. As we sit here now, the 4 who purport to have procured have committed a criminal offense and should be treated as such. So, in my opinion, what I understood my lady and the court to have said earlier in your ruling was that IEBC was properly represented by its advocates on this table. However, the 4 individual commissioners who are now cited as respondents but who are supporting the petition will continue to enjoy the very distinguished services of my senior learned friend, the Honorable Paul Mwita.
Your Ladyship, Madam CJ, there is something that is likely to be lost as my 2 learned friends are fighting. And it is so important, it could compromise really the fairness of the hearing which you have endeavored with so much effort to craft a way forward. It is this: 8 petitions were filed against my client within the 7 days cast in stone in the Constitution. It is the first time in this republic that 8 are filed. In 2013, there were 2. But because of ingenuity of this side of the court, we now can file very many, all intended for the same purpose. That aside, I burnt midnight oil, filed my response within time. Then comes the group of 4 commissioners. On 26th August, they have filed a response to the petition. They are filing this under the pretext they are respondents. They file a response. It is not a response. It is a new petition. There are new claims, new grievances, new grounds for nullification of my client's electoral victory.
Senior counsel.
Yes.
I think a ruling was delivered on their participation as respondents.
If you could just allow me 1 minute.
What we are addressing is whether they should be represented by lawyers of IEBC.
I was dealing with the response that they have filed. And that is the point that I think my learned friend, Githu Muigai, was alluding to. Will that response still be on record, or are they limited to the affidavits that they had filed and which have been allowed? Because if the response is also part of the record, a response filed or a new petition filed outside time, I do not know whether I need to respond to it and whether it will be admitted by the court, notwithstanding the strictures in Article 140. I hope
We've got a new senior counsel. What we are dealing with is the application of whether we should allow counsel to represent the 4 commissioners. As you can see, the 2 factions are insisting they are representing IEBC.
And in the mix of it, is that response that has been filed by Learned Counsel Paul Muite's team.
We
maybe
will retire to consider that application.
Please.
Which was, I think, filed out of time. So
yes, that
last night.
Is filed out of time.
We'll consider it and come back with a ruling.
Correct.
Yes.
That's number one. Number two, again, something which may be lost out. When I look around me, my colleagues each representing a party. And as you said, some could be secondary petitions. They each have, under the guideline you give, 4 lawyers each. Very carefully, I did.
It's only the main parties who have 4 lawyers.
All the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. Is each 2-2? Or, huh?
Mr. Ngatia, the other petitioners have 2, not 4.
Oh, very well.
So you really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has 2, they are 8, 16, or against nullification of 1 person. And then that 1 person, you limit him to 4 lawyers. I appreciate, I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a team of 4. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I have been allowed 3 hours. I would have requested you, Madam CJ, if there's any way you could, allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.
My lady, if I may. My lady, if I may have your indulgence for only 1 minute. I noticed that my lady observes that this application was filed out of time, and we admit that that is so. But the reason is that it is not one of the applications contemplated under the rules. Issa Mansour, Esquire, filed his papers on the 26th. We did not expect that there would be another petition filed in the guise of a response, because what the 4 commissioners have done is to file a fresh presidential petition outside the constitutional timelines. We agonized as to what we ought to do in the circumstances, and the only thing open to us was to make the application on the 29th. So we beseech you that if you find that it is out of the normal timeline, you nonetheless grant us an extension of time, because resolving this matter is very fundamental to resolving the petition. It is, my lady, this court that has repeatedly cautioned us that we should never attempt to resolve such a weighty matter as to who is the legitimate president of the Republic of Kenya on the basis of subterfuge. And I do pray, therefore, that you consider very seriously, my lady, that application, so that you may guide us accordingly. As regards time, we have another request. we are facing 7 petitions. And all these people are attacking the integrity of our technology, the capacity of our personnel, and above all else, the integrity of our chairman. We would ask for just 1 more hour so that we can meet these 7 petitions that have been allocated 10 hours. Thank you very much, my lady.
My lady, the President of the court and members of the court, I think the court has been very fair. Looking at the time allocation, we have 7 petitions, and in all those 7 petitions, we have been given a total of 6 hours, with a little bit more time for the petition number 5. We have 3 hours. The respondents similarly have 6 hours. And I think that taking into consideration the time that you have to hear and determine the petitions, I think that the time allocation has been very fair. Otherwise, if you have to follow the arguments by my learned friends for the IEBC, you would similarly say that our petitioners had a lot more to lose than the other petitioners, and therefore we should be given a little more time. But I think in the circumstances, I think the court has given a fair consideration as to the interests of all the parties and how to accommodate all the parties. 6 hours for the petitioners and 6 hours for the respondents. It's 6 hours. I think you do a little bit of mathematics, you'll find. I did a little bit of mathematics. The other matter that I wish to draw the court's attention there are other pleadings that have been filed out of time without the leave of court. I would invite the court to look at those pleadings that have been filed out of court, out of time, and without the leave of court, to be struck out, because parties that have been served with these pleadings at the last hour would not be able to respond to them. And one particular affidavit which has been served, filed out of time, is the affidavit that on the face of it is by one Hilda Kavonga. That has been filed by the Electoral Commission, the first faction of the Electoral Commission. And at the last page, it says it's been sworn by Martin Wachira Nyaga. So some mutation, biological mutation, must have taken place. And that, I don't know how to crack that one. But the bottom line is that they've been filed out of time and without leave of court.
Yes, the Honorable Madam Chief Justice and the court, I have a small application that I thought I would bring to the court's attention. Due to late service of responses, the first respondent, the first petitioner in petition number E007 prepared responses and a further affidavit that were brought to the attention of the registry, but were rejected because of the question of time. In the same breath as my learned friend Professor Githu Muigai, who has not filed a response to an application by ISA, we would seek leave, Your Ladyship, to file the affidavit. It's a small further affidavit of only 44 paragraphs, which is as a result of late service, Your Ladyship, and submissions by the first petitioner in E007. Your Ladyship, in terms of representation, just weighing in on what my learned friend has submitted, Mr. Professor Gideon Mugai, Senior Counsel, there are only 2 professors and senior counsel in court, the 2 of us. Why can't all of them appear for the IBC? All the senior counsel can appear for IBC so that the court is richer with submissions from all parties, so that we hear the Chebukati faction and the Cherere faction, and I think the court then can make a good decision. Last, Your Ladyship, on the question of time, I just want to confirm that we only have 6 hours, like Senior Counsel Rengo said. And if my learned friend thinks that there are too many petitions, they can concede. That's all.
If may please, my lady, Honorable Chief Justice and my lords, on behalf of the petitioners in petition number 3, we were served in time by a set of documents from the IEBC. Then subsequently, last night, we were served with another set of documents from IEBC. Rule 11 of this court's rules are very clear on filing and service within 4 days. And we are greatly prejudiced if documents that were filed and served outside time does not allow us a rejoinder, and then those documents now constitute part of the record. We'll urge my ladies and my lords that when you consider the issue of representation of IEBC, please take into account that in respect to petition number 3, the IEBC faction, minority faction, served us with their documents outside time, and we had no opportunity to file any rejoinder. So that whatever they filed, we cannot speak to it.
Can you name the party who filed late?
It was filed by.
It was filed late.
It was served on us late. We were served last night by the law firm of GA and Company Advocates. And we received the documents under protest and did indicate. Our prejudice is we cannot file any rejoinder to all the issues they've raised.
Please repeat the particular document which was filed late and by who? Which party?
My lady, I can speak to the service. We were served last evening. They are the first and second respondents' documents filed by the law firm of G&A Advocates. The response to the petition from the same law firm. There is a replying affidavit by Michael Ouma, filed from the same law firm. The first respondent's replying affidavit, filed by the same law firm. All those, and there's several volumes of volume 1, volume 2, and volume 2 of their supporting documents was served on us yesterday in the evening. And under Rule 11, they were meant to file and serve within 4 days of filing the petition. We have a 1 day to respond. We cannot respond to all those documents that they filed. And we urge this court to be guided by the case of Raila Odinga 2013, that late service of the documents on us has prejudiced us, and the information therein should be expunged from the record. That's all, my lady.
Thank you.
Sorry, my lady, if with the indulgence, I can also enumerate the pleadings which have been filed out of time. The first one is an affidavit by Oduor Juma Joseph, filed in support of the first and second respondents by G&A Advocates. This was filed on Monday at midnight. That is last night. The second one is an affidavit by Moses Ledama Sunkuli, and that affidavit has been drawn by the firm of Iseme, Kamau, and Maema, who are acting for the first and second respondents. This was filed yesterday, and it was filed out of time. The third one, again filed yesterday, is by the same firm of advocates, Iseme, Kamau, and Maema, for the first and second respondents, and it was filed yesterday. Affidavit by Balang Gideon. The fourth one is also filed, this was filed on Sunday, the 28th. This one is an affidavit of Catherine Wambui Kamau. And this one has been filed by, I believe, the same firm of advocates. This was filed on Sunday. The other one is an affidavit filed by the firm of Kithure Kindiki and Associates. This was filed today. And there's an affidavit, a further affidavit by Raymond Kiprotich Bet. The other one is an affidavit sworn by Martin Wachira Nyaga, an affidavit drawn by the firm of Iseme, Kamau, and Maema for the first and second respondents. This was filed on the 30th of August. This was filed today. Today at 2:45 a.m. The other one is an affidavit by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema for the first and second respondents. It was filed today, 30th of August, 2022 at 2:45 a.m. The other one is also an affidavit sworn by Hilda Kavonga, drawn by the same firm of advocates for the first and second respondents, Iseme, Kamau, and Maema, filed on Sunday at 11 p.m. And the last one is an affidavit sworn by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema, on behalf of the first and second respondents. This was filed on the 28th of August, 2022. And as far as we're concerned, they were filed out of time and without the leave of the court.
Your Ladyship, we may actually go into a wrong series of saying what has been filed late and only taking certain documents and not all of them. As I was sitting here, I've been served with a petitioner's further affidavit filed today. Today's 29? Filed yesterday, 29. And this is an affidavit that has been filed by the firm of Kinoti and Kive Advocates. I think there is need now to take a stock of what has also been happening and which may not have been quite clear to the court. The e-filing system has had tremendous difficulties. and confirmed from the registrar, and I think all parties, where we tried to file, we had challenges, and that took a bit of time. But to me, because we all look first at our own self-interest, the beginning point is the response filed by the firm of ISA on 26th August, and which takes the form of a new petition. That would be the beginning point, because if you are to allow that, then that petition will stand unresponded to date, because I could not respond to a petition filed outside the 7 days. So as you consider all these rival arguments, allowing some and disallowing the others, I think the most fundamental would be the status of that response, which is in the nature of a new petition. Once that is resolved, the other petitions in my submission would be dealt with quite easily. That is all, Your Ladyship.
May it please you, my lady, the Chief Justice of the Supreme Court, my lords, my ladies, on behalf of the first and second respondents, that is the chairperson of the IEBC, Mr. Wafula Chebukati, and the IEBC itself, I would want to mention just 3 quick issues in response to the issues that have been raised. The first, my name is Eric Gumbo. The first issue, my lady, is that just as has been indicated by Melanet Senior, Fred Ngatia Senior Counsel, the IT infrastructure of the judiciary and the portal upon which these documents are supposed to be filed had a big problem on Saturday. We did an email to the judiciary, got a confirmation that indeed the system was slow. And so that is the first reason why a number of documents came in late. Number 2, a number of these affidavits that have been alluded to before you this morning are affidavits that arose out of a response to affidavits that were filed by the same parties who are seeking to strike out these affidavits themselves. In particular, we got further affidavits from one John Gidongo. We got a further affidavit from one Arnold Ochieng. We got another affidavit from one George Joroge. And finally, one John Wesonga. These affidavits were filed way after the petition had been filed. They raised new issues. Specifically, they raised issues touching on the IT infrastructure of the IEBC. The most responsible thing to do, my lady and my lord, was for us to then do the affidavits. In fact, before they came in to raise the concern, we had ourselves wanted to raise this as a preliminary issue with the court so that we get directions. Because after we responded to the issues that they raised in their own further affidavits without leave, they again yesterday filed further affidavits seeking to now respond to the affidavits that we had filed responding to the issues they raised out of time. What is most interesting is that even in the affidavits that they filed as late as yesterday, they still raised new issues seeking to expand the 4 corners of the petition that is currently before the court, which then has the effect of making that petition mutate in form and character. Now, that said, my ladies and my lord, from where we sit, because of the significance of the issue at hand, we had taken the pragmatic approach to say that even
even though they served us late yesterday, that is late last night, we worked into the wee hours this morning and did our draft responses to those issues, so that if the court be minded to consider those issues, because I think some of them are pertinent to be able to go to what we are dealing with, then those affidavits could be put in place. We'd be allowed to file those, the ones that we had not served, responding to the areas that they raised in the affidavits yesterday. In the alternative, that then the affidavits that they filed yesterday should be struck off, so that then we are not prejudiced ourselves. But secondly, and perhaps more importantly, because clarity as to which affidavit was filed in time, perhaps the best approach would be to ask the parties to file formal applications, raise the concerns with specific documents, and we'll have an opportunity within this day today to demonstrate whether or not any of the affidavits was served out of time. I think that would give us clarity in such a way that no party would be prejudiced. I am most obliged.
Mr. Ngumbo, those affidavits were cited by Senior Counsel Orengo.
Yes.
Mr. Ngatia,
sorry.
Mr. Ngatia, as senior counsel, you ought to know how to conduct yourself.
Affidavits which the Chief Justice has asked are not the ones that were enumerated by learned counsel Mr. Orengo. They are the new affidavits that were filed and served yesterday are as follows. The first one is an affidavit by Martha Karoa, Senior Counsel, of 28th August and served yesterday. The second one also by Martha Karoa of 27th August and sworn on 28th, and we received it yesterday. Celestine Anyango Opio, sworn on 28th August and served yesterday. George Joroge, sworn on 28th and served yesterday. John Mark Githongo, sworn on 28th and served yesterday. Edgar Ouko, sworn 28th, served yesterday. Benson Wesonga, this was served yesterday. Yes, sworn 28th and served yesterday. Arnold Oshieng, 28th is the date of swearing, served yesterday. John Githongo, once again, 28th August, date of swearing and service yesterday. Those are the ones that prompted a fury of activity on our part to try and respond to them. I'm in the same position as learned counsel. We try to work very hard, but by the time again we try to file, the system did not allow us to file. So we have new matters which have been raised, which we have not responded to. May I apologize to my Lord, Supreme Court Judge, and thank you for reminding me yet again. I am sorry, the whisper was not meant for the court, but to learned counsel. Thank you.
My Lady, the Chief Justice, you had asked a question about the specific affidavits. My learned senior, Fred Ngatia, Senior Counsel, has given the list of those affidavits. In fact, the ones that have been served on us are the ones from John Gidongo, Arnold Ochieng, John Joroge, and Benson Wesonga. And my lady, I just wanted to mention that so that we are able to contextualize this affidavit, when we were served with the petition, we had a specific time within which to respond. We responded in time and served those responses. When the petitioners saw our responses, without the leave of the court, they filed further affidavits. Now, when those affidavits were served on us, we thought that perhaps instead of coming to us for leave, we do the pragmatic thing of responding to them, then we come and have them formally, we get directions from the court on how to deal with them. Because it would have meant that we would be making an application for leave today to file in further affidavits. It also then means that if we are to get to the four corners of the petition, then we must get back to the first date in time. After filing our responses, what came up? The new affidavits. How do we deal with them? That would be the question. I had given a proposal that because some of them seem to raise a number of important issues, and we have satisfactorily responded to those issues, we could deem all those affidavits as properly served, filed and served, so that then we forget about the side issues and go to the petition. More specifically, now that you have given us the issues that we need to be addressing you on. I am most obliged, my lady.
I'm sorry, this may be a back and forward, but there are directions which were issued by the court. This, I think, was on the 23rd of August 2022, and the directions required, if I don't go through all the directions, it required the respondents to file and serve their responses together with their written submissions and bundle of authorities on or before 5 p.m. on the 27th of August 2022. The petitioners then were directed to file and serve their rejoinder, if any, on the 28th of August 2022. So the affidavits they've been referring to, which were filed by the petitioners, were rejoinders to the affidavits they had filed on the 27th of August 2022. So looked at in that context, we were quite in order to file those rejoinders in terms of affidavits yesterday, on the 28th, not yesterday, 28th. And I think there was a further directions that there would be a close of pleadings on the 28th of August 2022. So that is the context in which I brought the question of the late filing of these or the affidavits I enumerated. As to the infrastructure of the court, we were in a similar position, but when we made inquiries with the registrar, we were told that if we had any problems with filing any documents online, then you could physically take the documents to the registry, and that's what we did. And there were absolutely no problem about it. In fact, because of those particular problems, in cases where we were required to file by 5 p.m., I think on inquiry we were told we could file the documents same day, but on or before 9 p.m. So I think the registry was quite helpful, and anybody who wanted to file a document within time, there were absolutely no problem at all insofar as the registry is concerned. But probably the court should look at all these documents, put them in context, and then make a decision. But our position is that the affidavits that I mentioned were filed out of time and without leave of court. We would need a demonstration that what we filed on the 28th was not in line with the directions that were given by the court.
Thank you. We are hoping we could bring this to an end so that...
Good afternoon, Lady Chief Justice, the Deputy Chief Justice and Judges of the Supreme Court. My name is Mansour Issa. I am being led by Senior Counsel Paul Mwite. My ladies, my teacher, Professor, and my People Master, Senior Counsel, Professor Guido Mwegai, has alluded to the application that was filed by the firm of Iseme Kamau and Maema in the wee hours of yesterday. That application was filed on us at 3 in the morning, I think the first one. We had seen copies of that application on the portal before it was served, and we worked yesterday in the evening with the vice chairperson of the IEBC, to prepare responses to that application before it was filed. And when we tried to file the application today morning, the registry indicated they had not received the application that both parties have referred to. And indeed, Senior Counsel Kamau Karori has confirmed the hard copies of the application had not been presented to the court. So, my ladies, as you retire to consider that application, we have filed our responses online and would kindly request that the hard copies and the submissions that our clerks have presented to the court be considered, because there was very late service, and I believe it's because of the difficulties with the e-filing. It was for quite a while yesterday down, but they should have sent us advance copies. But there was no prejudice because we managed to see it in good time, as alerted by my learned friend, Ms. Njue. She was trying to file something. When she saw those applications, she called me. I was still reading, and we managed to file our responses to those applications. So we will abide by the directions given by the court, because we had filed all our responses on behalf of the Commission as directed by the Commissioners. Thank you, and have a good afternoon.
My lady, if I may. My name is Kibe Mongai. I appear in petition number 8. I rise in order to speak to two things. Number one is that my learned colleague, Mr. Ngatia, has spoken about a petitioner's further affidavit that he claims was filed and served late. My lady and my lords, this further affidavit was sworn on 28th and served on them before midnight of that day, the Sunday that we were entitled to do our rejoinder. They were served, all of them. But more importantly, the affidavits of the IEBC and Mr. Wafula Chebukati were served on us on Sunday at noon. So that there was a question of the time when our 24 hours was going to run. But despite all that, we filed the affidavit on time and served, but we could not be able to file because there was a problem, and we were told, and the following day when we presented document and we explained, they were admitted, so that he's only referring to the issue of the physical copy. And the original trigger was by IEBC. But we decided not to break bones, and we've not said IEBC served us with anything late. It came on Sunday, and we responded. And therefore, as far as we are concerned, the only issue that we did yesterday, and we filed, but it requires that just to be submitted to the court, are our submissions. But they were still done within the 24 hours, but the system was down. We were told as soon as it is there, file it, and then present. So that as far as we are concerned, all our documents are in place and filed on time. Having finished with that issue of petition 008, it is my hope that no directions may have been given without me getting to know of that issue. But the court will note that there has been correspondence between my office and at least with the registrar with regard to petition number 22, E025, between Kenneth Jagejiro and 10 others versus Honorable William Samoei and Honorable Rigathi Gachagua. May the court note that that petition that was filed on the 5th of August this year
relates to the issues of the validity of the nominations of Honorable William Ruto and Rigathi Gachagua.
Yes, with utmost humility, Mr. Kibe, we are dealing with Article 140, matters that arose from the dispute on whether the president-elect was validly elected. Those matters were filed before the elections and before the declaration. So you wait for the ruling, it will be delivered.
It will be delivered.
It's a separate matter from what we are dealing with. So let's not go there.
It's okay, my lady. I'll go by that. Thank you.
We want to bring this to an end on the three issues that have been addressed to the court.
With your kind permission.
That is the time allocation, representation of the two factions of the INBC, and the documents that have been filed in court with or without leave of the court. The court would wish to adjourn to consider those matters and resume at 3:30. I will also kindly ask the parties to furnish the registrar with those documents, because documents have come, so many documents have come, so that we can be able to look at them and deliver our further directions at 3:30.
I'm not obliged, my lady.
Because we are just going around the three issues. The three issues of the time allocation, of the documents filed, which were found late, which were found without leave. Allow us to go and consider that, and the issue of representation.
Yes, my lord. Just one item, my lady, which...
You can't be addressing the court, two of you.
Yes. My lady, with your kind permission, my name is Kamau Karori, Senior Counsel. My lady, I just needed to comment on just two issues. The first is the allegation that the application that was filed to strike out the name of Issa and company advocates from the record, that it was not, the physical applications were not presented. The correct position, my lady, is that they were presented, but we were informed by the registry that in view of the fact that the court was sitting today, that the appropriate thing to do would be to come and seek leave of the court before the documents are received at the registry. So it is not true that we did not serve those documents. Secondly, my lady, regarding the documents, there's also an important point, my lady, to point out, which is that the affidavit filed by John Githongo, he had filed a response first, then he filed a further affidavit out of time, and in that further affidavit, he introduced completely new documents. In fact, as you will notice when you retire to write your ruling, he now withdrew the initial logs that he had attached to his affidavit and filed completely new ones after we had responded to his previous affidavit. The only option available to us, having been served with these new documents, was now to respond to them. You'll also notice, my lady, that the documents filed by Arnold Oginga, again, they are completely new documents from the ones that had been filed earlier. The prejudice is, on the basis of the document that had been served upon us, we had already responded and filed submissions because our time for filing submissions was very limited. Now we have a situation where new documents have been filed. We have no opportunity of responding to them in submissions because our submissions have already been filed. The only option was for us to file an additional affidavit explaining or answering these new documents and assertions that had now been made. And that is why the documents that were filed out of time on account of the system issues that my learned friend has alluded to. Thank you, Madam.
Thank you.
With your permission, your ladyship, my lords, mine are separate and different issues. The first one relates to the orders you made for scrutiny this afternoon.
Please, can you introduce yourself?
Yes, my name is Katwa Kigen. For the first petition, led by my senior, Mr. Ngatia. It relates to...
Respondent, you mean?
Yes, first respondent. I apologize for that. It relates to the issue of scrutiny that is supposed to start this afternoon. We would like to request that the court takes on board consideration of the issues of security
considering what happened at the National Tally Center, my lords and your lordships. And we would also like that the issue of the location where it is to be done be addressed. And we would prefer, considering the security issues also, that camera surveillance be addressed, my lords and my ladies. The second issue, my lords and my ladies, is you granted permission to the Attorney General to introduce 2 affidavits, and we would the 2 affidavits introduce very substantial facts that go to touch very seriously on our case, and we would like and pray for leave to respond to those affidavits, considering that you've allowed them in. Thank you, my ladies and my lords.
My Lady, the Chief Justice and judges of the court, my name is Charles Kanjama for the ICT professionals who've been admitted as amici. I have also 2 requests to make to the court. One is that in respect of the scrutiny that will be taking place, that the amici whose assistance to the court is to give independent observation of the election technology be allowed to participate and also be allowed thereafter to prepare and present their own independent report so that they can effectively assist the court. Second, in relation to the technology affidavits that have been filed late in the last 2 days, the amici in their initial report had responded to the initial technology affidavit so that they could give an independent perspective from ICT professionals. Would request that they also be granted leave so that they can supplement that report by also responding to the subsequent technology affidavits which this court is considering whether to admit. That is all.
My Lady Chief Justice, my name is Mituga. For the petitioner, in petition 004, I also have a problem of experience by the rest in filing documents when there was a system downturn. Our rejoinder was supposed to be filed on 28th, but due to system problems, although we filed our set of documents serving as a rejoinder, we presented them to court yesterday when they were stamped as filed out of time. In considering the rest of the document filed out of time, we asked the court also to consider the 4th respondent's document, supplementary submissions, the supplementary affidavit, and list and bundle of documents dated and filed on 28th of August 2022.
Lordship, why, in view of all these counter arguments, the petitioners, respondents filing late, claiming, Your Lordship, if the court could just give us 1 hour to regularize so that no party then excludes anything from the record, that would serve the interest of justice. And I submit, Your Lordship, that then no party will feel that they've been locked out. So we don't go back to Raila 2013, where huge documents are locked out, and we all find fairness in this court.
Thank you. You know, our time is not elastic. There was an order for scrutiny from 2 p.m., so we really have to adjourn now.
I just wanted clarity on the role of the amici. It would appear that they want to go beyond their role.
Senior counsel, we will deal with that. We are capable of dealing with it. We already gave directions that we will rely on the amici brief that is already on record. Rulings have been issued to that effect. Yes. So with your kind permission, the court will adjourn, and we will reconvene at 4 p.m. because of the many issues that have been raised.
See now, the Supreme Court judges, 7 of them are leaving the court to make a determination on 3 issues: on time management, the service of the document, and also the representation. This is after they did some housekeeping, so to say, in terms of the pre-trial conference that started at about 11 o'clock. They have now retired to make their rulings on 3 key issues after the housekeeping. Let's look at the housekeeping. Of course, I'm still with my panelists here. We have Churchill Saoke, who is a governance expert and a lecturer at the JQAT, and we also have a constitutional lawyer who happens to be Henry Kurauka. Gentlemen, karibuni sana.
Asante sana.
We have been following this keenly, and I'm quite sure this pre-trial conference answers a lot of questions for Kenyans who are asking what exactly is a pre-trial conference. That is exactly what has just transpired. You see, there's nothing that they have raised of substance in regards to the case. They haven't touched the merits of the case yet, but they were just keeping time management. Of course, there are some of the rulings that they have been able to give by that court. The first time is that they've urged that there will be a strict time management, as CJ has talked about. They do not have the luxury of elasticity when it comes to time. And of course, they will limit the number of councils. You remember, we have only 5 days to have the final decisions. They have talked about 25 preliminary issues have already been dispensed, and 2 petitions have been struck out. As we told you earlier, is that the Moses Kuria one was dispensed. One of the reasons being the jurisdiction of the court. If he indeed needs to refile, he has to go to the High Court. Another thing is that they have consolidated the 7 cases now. They are 1, and this petition now officially has been baptized, and its name is Raila Odinga and Martha Karua petition. And they will be given, for the first day, they will be given 3 hours. That is the side of Raila Odinga, and also the first respondent being President-elect William Ruto and his deputy Rigathi Gachagua. And talked about 9 issues set for determination. And before, gentlemen, we go to the 9 issues set for determination, Wakili, there's an issue I had raised here earlier on, and it seems to still be dogging the proceedings today. That is on time. Time is of essence. Time is quite limited, even for this petition.
Yes, it is true.
That is outside, just a minute, Council, that is outside the Milimani law courts, and the councils will also be moving to deliberate on the 9 issues that the court has talked about will be issues for determination. And after that, they will be reconvening at about 4 p.m., being the first ruling of the day. And you can see there the councils, of course, they had so many issues. Majority of those councils who have risen up have raised the issue on time. They're asking for more time, which the court says we do not have that time. We have to share the little time, the little time that we have, and manage it well. Wakili.
Yes, unfortunately, we have only 14 days from the date of filing the petitions to have the judgment. Therefore, the pressure on the judges is extremely high, considering the volume of work, the documents, the evidence, and also the great public interest in this petition. Therefore, in my view, the judges are very correct when they say that they cannot at lunchtime. Of course, we need at most 3 days to finish with oral submissions to allow the judges to retire, to write a judgment,
that must be rendered by Monday 5th. Now, if you look at the time allocated, it is reasonable. The petitions may be 7, they may be more, but the final orders are substantially the same. All the petitions are seeking to invalidate the presidential elections. The facts relied upon in all the petitions appear to be similar with a few modifications. And the issues framed are fairly done by the judges, correctly done, and if all these issues are answered by the judges and analyzed, then we expect a fair judgment. But let me say this. The main issue that the judges must resolve is whether or not the elections were fair, credible, and transparent in accordance with our Constitution and the election laws. And it is important for Kenyans to know that the judges have an obligation to render a judgment. Unlike the IBC, where 4 out of 7 decision was ignored, the judges, if the fate of these petitions lie on at least 4 out of the 7 judges. So if 4 judges make a determination, that should carry the day. Thank you. Doc, I would like us, before we mention the 9 issues that are set for determination, this is what we will be dealing with for the next 5 days. And from these 9 issues is where we expect a determination on this suit. Again, the CJ there noted and said, other than talking about the elasticity of time, also talked about the 14 days being cast in stone. In 2013, as she has mentioned, is that we only had 2 petitions, which of course gives a little bit of flexibility in matters of time. But you see, all the councils that have risen, the major issue that have brought about is the issue of time. Perhaps we need to relook at that as well.
Well, I like one, we have to submit that the lawyers, their role is to defend the clients, and the best way to defend the clients is to ensure that you speak as much as possible, and to speak as much as possible you need time. So it will be expected that however much the number of petitions are, they will still need more time. And I think that you see, the way the Chief Justice is trying to bring out these issues, he is able to very skillfully and tactfully collapse the issues. Like for example, when they were giving their responses after the judges, she had given her rulings on how, she had given her briefings on how the court will conduct its activities. You could see there was a lot of, the lawyers are coming, they need time, the issues of documents and things like that. And everybody is speaking, trying to defend their positions, which is expected. And she comes and collapses these things into just 3 key issues. So I find that skill, it's quite good. And I mean, I expect that even moving forward, even in as much as the lawyers will speak to defend their clients, it's also their skill as judges to see deep through what are they saying, in the many words, what are they saying, what are the key issues, so that you handle the key things that are important for this petition.
And we seem to always be doing deadlines, because I remember even Wafula Chebukati was almost hitting the deadline of announcing the presidential election. Azimio had 1 week to file and serve. They did that on the last day.
It is important.
And I also remember on Sunday, being the last day for the Amici, was that they filed on the last day. And this seemed to be a recurrence. And they've talked about technology failing. The judiciary, they talked about we tried, but it didn't. This, of course, affects the timeline.
Some of these things, first of all, we have to admit that there is a need for timelines. The Constitution has set it as so that there is order in decision making. 2, there is the tact of the process that many of the actors will want to employ to ensure that, if you are to provide information, you provide it the last at the last minute. That's why I think you're seeing some of the affidavits were even coming after. It's part of the tact of the game to find ways of
not to give your opponent enough time to practice.
Exactly.
Okay.
Exactly.
Wakili, I know we cannot go into the merits of the case. The 9 issues set for determination. There were issues, so many issues. Looking at all the petitions before they were collapsed and before some were struck out, looking at the petition themselves, they raised so many questions, but from the Solomonic wisdom of the judges, the first ruling that they've made, they have been able to collapse that into 9. And allow me, if my director can allow me very quickly, the first issue set for determination will be whether the technology deployed by IEBC for the conduct of the 2022 general election met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Another one is whether the forms, there was interference with the uploading and transmission of the Form 34A from the polling station to the IEBC public portal. And still on this, something touching on the Form 34A, the third one being whether there was a difference between Form 34A uploaded on the IEBC public portal and on the Form 34A received at the National Tallying Center and Form 34A issued to the agents at the polling station. Those are some of, just in a nutshell. And the last one, talking about what reliefs or orders can the court grant the issue. Okay, first of all, just hold the thought. We need to cross over to Mombasa. Now we'll be crossing over to Mombasa. We have new governors, but we, as IEBC said, is that we have to wait for them to declare, but they have already declared for the results of Kakamega, where Fernandez Baraza of ODM has been able to take that seat. It was a neck and neck election, if you ask me, between him and the ANC party candidate who happened to be the Senator Cleophas Malala. Maybe your input on that, gentlemen? Beginning with you, Wakili.
Thank you very much. When all the petitions were consolidated, it then becomes only one petition. And that's why it is saved a lot of our time. We expect each party will be having fewer minutes than in a situation where we have separate petitions. On the issues framed, the judges are guided by the Constitution, by the law, and the main issue for determination is whether these elections meet the threshold provided by our laws and also the Constitution. That is fairness, whether they are credible, whether they are transparent, and whether they meet the wishes of the voters. On all the technicalities, the procedural aspects, and all that, that's something that will appear in their judgments. They will address issues of IT, issues of Form 34A, B, and so on issues of, suppressed voter turnout, issues of verification. And remember, verification, counting, and, all that is different. So we expect the judges to make a finding on that. But the final reliefs are likely to be two. Either the elections were valid, in which case the judges will proceed to declare the person, Dr. Ruto, as validly elected, and probably under that each party bears its own costs. The second prayer that they are likely to give is to invalidate the elections, in which case we go straight to fresh elections within 60 days. And of course, I do expect, going by the previous precedent, for them to, under each party, to bear own costs. About the timelines, the previous precedent is that the timelines for filing documents is not extendable. However, the Supreme Court is not bound by its own decisions. It can vary them, it can vacate them, it can, set new standards and new procedures.
And by that you mean that they don't really need to rely on what they decided on in the year 2017?
Precisely, because you realize now we have the e-filing system. for the last few days, there was a serious problem with our online filing system. At the end, we could not file documents. So that can maybe inform the judges to animate documents that were filed out of court, out of time. And I think those are some of the issues we expect at about 4 p.m. tonight.
All right. And because of the interest of time, Churchill, I would like you to actually to have your closing remarks and, of course, also infuse what we have, the two by-elections, and especially when it comes to the gubernatorial seats that we were looking at.
Yeah, I think on to the petitions, I think the precedents have already been set, and we expect, the world is watching Kenya, and we've been an example for the region. So we expect that the judges and all those who are involved in the process to uphold high-level integrity and in a manner that reflects the best of Kenya. On the election, I think that the turnout was low, pretty low, but we appreciate the fact that there may have been issues that may have affected that, and we are happy that it was generally peaceful, and the results have come out faster this time round. People are not too anxious waiting. So and also the other thing is that those who have lost have also considered defeat. So that's also something that is good.
All right. Your final sentiment before we cross over to Serafina, who is waiting to give us a brief of what has just transpired.
Congratulations to our new leaders. You fought for it, and also congratulations to the leaders who were not elected, but they conceded. There is another time to fight. My final remarks are that whatever the outcome of this petition, we should safeguard our country, Kenya. We should, maintain peace, tranquility, because that is the most important thing. We need to be there tomorrow. We need to be happy. We need to move on with our activities. Thank you.
Thank you so much. And talking of elections, that is also something that is set for determination on whether the two gubernatorial positions that we were having elections yesterday did impede on the election. That is one thing also that will be set for determination. Let's now cross over to the Milimani Law Courts, where the Supreme Court is domiciled for this hearing, and we have Serafina on the line to give us just a brief overview of what has just transpired. Serafina? Yeah. Okay. As we wait for that, perhaps I can get 1 minute in regards to how the actions had. But okay, we have now Serafina on the line. Serafina?
Yes, a very good afternoon, Troy. We're coming to you live from the Milimani Law Courts, whereby we continue to follow up on the just concluded pre-trial conference, whereby the 7-judge bench of the Supreme Court has just given guidelines on how the hearing will take place, given that it's supposed to kick off starting tomorrow. And also in regards to the petitions that had been filed earlier on, what we've gotten from the 7-judge bench is that they've been able to consolidate 7 of the petitions and struck out 2 of the petitions that had been filed in regards to the presidential election petitions. And some of the 2 that have been struck out in regards to this is one that had been filed by politician Moses Kuria, whereby he was disputing that some of the activities that happened at the National Tallying Center, which is at Bomas, was that some of the representatives of the Azimio la Umoja coalition were able to get to that place and cause commotion. Therefore, their petition should not be heard. And the other petition was one filed by a musician come politician who is Ruben Kigame, who was also seeking for the presidential election petition to be dismissed, saying that his rights had not been considered, his rights had been violated since he was not allowed to participate in the just concluded presidential elections. Therefore, he sought for the election petition to be annulled, the presidential election results to be annulled, so that he could be allowed to participate in the next elections, general elections of the presidential presidential position. Also from this, we're able to get some of the 9 issues that the Supreme Court judges will be considering, and some of the issues, if I can just read them out to you, are whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. The other issue or ground that will be considered will be whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IEBC public portal, and also whether there was a difference between the Forms 34A uploaded, the Forms 34A that were brought by the returning officers to the National Tallying Center, as well as the Forms 34A that were given to the agents. The other issue is whether there was a difference between the Forms 34A uploaded on the IEBC portal, and also the fourth issue is whether the postponement of the gubernatorial elections in Kakamega, in Mombasa, and also for the Member of Parliament positions in Kasheliba, in Pokot South, in Kitui Rural, as well as in Drungai, and also in Nyaki wards, as well as Kwanjenga, were able to suppress, of course, voter suppression to the detriment of the petitioners in the petition. Also, whether there were unexplainable discrepancies between the votes cast for the presidential position and those cast for the other positions. The other issue that will be determined in this hearing is whether the IEBC whether the IEBC carried out the verification, tallying, and declaration of the results in accordance with Article 138 of the Constitution, whether the declared president-elect attained 50+1 votes as required by the Constitution and Article 138, Sub-Article 4 of the Constitution, and also whether there were irregularities and illegalities of such a magnitude to affect the final results of the presidential elections, and also what reliefs and orders can the court grant or issue in regards to this presidential election petition. Also, other guidelines that were given by the 7-judge bench led by the Chief Justice Martha Koome was on how the petitioners, the main petitioners who are Raila Odinga and his running mate Martha Karua, were given time on which they'll be able to make the submissions, whereby they were allocated about 3 hours to make their submissions, and the other petitioners were allocated each 30 minutes, and thereafter also they now looked at the respondents, and key from the respondents, they first looked at the commissioners who are supporting the petition, led by the deputy of the chair of the IEBC, is Juliana Cherera, whereby they said that all the 4 commissioners who are supporting the petition filed by Azimio and the other petitioners have been allocated 1 hour to get to share it, and also the other respondents, William Ruto and Rigathi Gachagua, have been allocated 3 hours, and then also the IEBC and the chair have been allocated 3 hours. And thereafter, what will follow next, they've also looked at the amicus curiae, or the amici curiae that applied to be enjoined in this petition as friends of the court. However, I'm going to be joined by one of my colleagues who is also here at the Supreme Court to get to understand what has been issued in regards to that. Yes, Mohammed.
Thank you very much, Sarafina. It is according to the time allocated by the various advocates and the councils, the amicus curiae, who include the law societies of Kenya, 3 ICT officials who are represented by lawyer Charles Kanjama and ICJ Kenya, or they haven't been given time allocation, but they were told no oral submission by the court, and as the 9 issues are going to be addressed in court, they can, and that is briefly, they are allowed to submit briefs that are already on records. Yeah, that is since they don't have the time allocated to them, whereas the other advocates and the council members have been given 3 hours and various time allocated to them. Thank you.
Okay, that is one of my colleagues here, who is Abdikhair Mohammed, just giving us a brief in regards to the amicus curiae or amici curiae who have been allowed so far. As he has indicated, is that only 3 amici curiae have been allowed in this petition, who include the Law Society of Kenya, as he has stated, ICJ Kenya, as well as 3 ICT officials who are being represented by lawyer Charles Kanjama. These are the amici curiae that will be in this petition. And also, as he has indicated, is that they have not been allowed to make oral submissions in regards to this petition, but rather their briefs will be considered during the hearing. So far as of now is that the bench has adjourned to go and consider some of the issues that had been raised by different parties during the pre-trial conference. They're going to reconvene at 4 p.m. I'm now going to hand you over to my colleague Ben Chumba, who is also here at the Milimani Law Court, where the Supreme Court is hearing the presidential election petitions. To you, Chumba.
Asante sana mwenzangu Sarafina Robi, ambaye tumekita kambi naye hapa katika mahakama ya Milimani. Mtazamaji, mahakama ya Milimani ndipo shughuli ama kikao cha kuweza kusikiliza kesi ya kupinga ushindi wa Rais mteule William Ruto katika mahakama ya upeo. Ni kesi ambayo iliweza kuwasilishwa katika mahakama ya upeo na aliyekuwa mwaniaji wa Azimio Raila Odinga pamoja na mwaniaji mwenza ambaye ni Martha Karua, wakisema kwamba uchaguzi ambao uliandaliwa nchini haukuwa wa uadilifu ama hukuzingatia mahitaji ya katiba. Mtazamaji, tu hapa nipo tayari kabisa kukueleza jinsi mambo yametukia kuanzia asubuhi na mapema mwendo wa saa 5, wakati ambapo wale majaji waliweza kujitokeza ili kuweza kushuhudia kikao cha kwanza. Ni kikao ambacho kinafanyika shughuli ya kutathmini kesi. Ili kukueleza kinagaubaga hapa studio ya muda ninaye wakili Dennis Moroga. Wakili Dennis Moroga ni wakili katika mahakama pia, na pia yeye ni mhadhiri katika chuo kikuu cha Moi. Kwa hivyo atakuwa anatusaidia kwa uchanganuzi kidogo kuhusiana na masuala ya sheria. Karibu sana Dennis.
Asante.
Bila kupoteza wakati, tueleze watazamaji wetu umuhimu wa kikao cha leo. Kwa nini kikao cha leo ni muhimu sana?
Kikao cha leo ni cha muhimu sana kwa sababu pia namna ambavyo tumeona tangu kesi zilianza kuwekwa kotini,
ndio
tumeona kuwa kesi zimekuwa nyingi, na pia kuna swala ibuka ambayo yametokea tangu kesi ya kwanza kuwasilishwa. Umeona wale ambao wanasema watu walienda labda bomas, vitu kama hizo. Kwa hivyo sasa kikao cha leo ni kuweka wazi mambo yapi ambayo koti itatilia manani wakati ambapo inaenda kutoa uamuzi.
Ndio.
Kwa sababu sio mambo yote ambayo yamefika kotini koti itatilia manani wakati wa kutoa uamuzi. Kumbuka kuwa cha muhimu ni kama uchaguzi ulikuwa wa wazi na ambao pia kulikuwa na haki ambayo ilitendeka wakati wa uchaguzi. Hilo ndilo la muhimu sana. Kwa hivyo leo ni kuweka tu sawia mambo ya muhimu sana ambayo yanafaa kuamuliwa na koti. Pia kuna kesi nyingi ambazo ziliwakilishwa kotini na muda wa koti pia sio mwingi sana. Kwa mfano kulikuwa na jumla ya kesi 9.
Ndio.
Tayari 2 zimekuwa struck out. Zingine ambazo zimesalia bado, hizo 7 ni nyingi sana kwa koti kusikiza kesi moja baada ya nyingine kwa muda kidogo ambao koti imepatiwa.
Ndio.
Kwa hivyo kikao cha leo kinasaidia pia kuangalia kwa hizi kesi zote ambazo zimewekwa kotini.
Ndio.
Kumbuka zote zinapinga ama zina challenge uchaguzi wa Rais mteule William Ruto. Kwa hivyo utapata kuwa zote mambo ambayo zinasema mengi mengi ni similar. Kwa hivyo tunaangalia yale ambayo yako common across all cases. Alafu pia sasa ndio koti inazingatia hayo. Kuna yale mengine ambayo labda petitioner mmoja ameweka na sio ya muhimu sana kwa kesi, hayo koti haitazingatia.
Kupitia pia kikao cha leo tumeweza kuona mawakili wakijitambulisha. Tumeona Githu Muigai pale akisema anaiwakilisha tume ya IBC. Kuna Fred Ngatia ambaye atakuwa anawakilisha William Ruto katika kesi hii, alafu pia James Orengo pia atakuwa anawakilisha upande wa Azimio. Mtazamaji, kidogo nakatiza mahojiano hayo kwa sababu naarifiwa kidogo tunaenda moja kwa moja hadi kaunti ya Mombasa kusikia ni yepi yanajiri. Kumbuka kwamba hapo jana kulikuwepo na uchaguzi katika kaunti hile ya Mombasa.
Njue constituency 002, Hezron Awiti Bolo 127, Hassan Omar Hassan 11,038, William Kazungu Kingi 91, Daniel Munga Kitao 40, Shafi Mwaganda Makazi 58, Abdulswamad Sharif Nasir 15,629, Said Abdallah Omar 56. Votes cast in Njue constituency 27,039, rejected votes 272, valid votes 27,039. Constituency 003, Kisauni, Hezron Awiti Bolo 170, Hassan Omar Hassan 20,750, William Kazungu Kingi 241, Daniel Munga Kitao 183, Shafi Mwaganda Makazi 242, Abdulswamad Sharif Nasir 21,796. Abdallah Omar 67, votes cast 43,449, rejected ballots 319, valid votes 43,449. Njue constituency, Hezron Awiti Bolo 267, Hassan Omar Hassan 21,580, William Kazungu Kingi 186, Daniel Munga Kitao 59, Shafi Mwaganda Makazi 121, Abdulswamad Sharif Nasir 22,387. Abdallah Omar 64, votes cast for votes cast 44,664, rejected ballots 261, valid votes 44,664. 005 Likoni constituency, Hezron Awiti Bolo 104, Hassan Omar Hassan 9,756, William Kazungu Kingi 47, Daniel Munga Kitao 38, Shafi Mwaganda Makazi 56, Abdulswamad Sharif Nasir 17,436. Said Abdallah Omar 55. Votes cast 27,481. Rejected ballots 214. Valid votes 27,481. (006) Mvita constituency. Hezron Awiti Bolo 102. Hassan Omar Hassan 19,083. William Kazungu Kingi 84. Daniel Munga Kitsao 61. Shafi Mwaganda Makazi 82. Abduswamad Sherif Nasir 24,106. Said Abdallah Omar 49. Votes cast 43,567. Rejected 1,019. Valid votes 43,567. Total results for the county. Total results for the county. Hezron Awiti Bolo 875. Hassan Omar Hassan 98,105. William Kazungu Kingi 712. Daniel Munga Kisao 402. Shafi Mwaganda Makazi 633. Abduswamad Sherif Nasir 119,000. Abduswamad Sherif Nasir. Abduswamad Sherif Nasir 119,083. Said Abdallah Omar 338. Votes cast 220,148. Rejected ballots 2,298. Valid votes 220,148. Swalha Yusuf, the county returning officer for Mombasa County, hereby declares that Abduswamad Sharif Nasir of ID number 006 Returning Officer, Mombasa County, hereby declares that Abdulsamad Sharif Nasir of ID number 13358416 as the duly elected County Governor for Mombasa in the county elections held on 29th day of August 2022.
Karibu tena mtazamaji kwa matangazo ya moja kwa moja kutoka eneo la Milimani hapa Nairobi, ambapo shughuli ya kuweza kusikiliza kesi ambayo imewasilishwa na Raila Odinga kupinga uchaguzi wa Rais mteule Dr. William Ruto. Na hapo awali kidogo umeweza kupata matangazo ya moja kwa moja kutoka kaunti ya Mombasa, ambapo Sharif Nasir ameweza kutangazwa mshindi kama gavana mteule wa kaunti ya Mombasa baada ya kumshinda mwenzake wa Kenya Kwanza Hassan Omar. Turudi katika mjadala wetu Bwana Moroga, na tulikuwa tunazungumzia mawakili ambao wameweza kujiwasilisha katika kikao cha leo. Tumeona kidogo kulikuwa na kutoelewana kidogo kati ya wakili Githu Muigai, Paul Muite na Isa Mansur. Labda ulizungumzia hilo swala kidogo.
Naam, hilo linatokana na yale matukio kwa tume, kwa sababu tume ya uchaguzi ni kama hakuna maelewano kati ya makomishona wanne na hao wengine wa timu ya Chebukati.
Ndio.
Kwa hivyo sasa kulikuwa na wakili ambao walikuwa hapo awali wamepewa nafasi kuwakilisha IBC.
Ndio.
Hii sasa ni uwakilishi wa tume. Baadaye pia hawa commissioners wanne waliweza kuteua mawakili ambao sasa wana represent pia IBC. Kwa hivyo sasa hizo pande zote mbili zina represent IBC, na ukiangalia kutokana na makaratasi ambayo wameweka kotini, mawakili wote hawatoki kwa upande mmoja. Wako pande kinzani, ila wanawakilisha mhusika mmoja ambaye ni IBC. Kwa hivyo koti ikirejea, baadhi ya maamuzi ambayo tunatarajia ni kwamba iamue nani ndiye atakayewakilisha tume.
Naam. Na hapo awali kidogo kabla kikao kwanza, tulikuwa tumeona kwamba mahakama iliweza kukubali kina wale makamishna wanne wa IBC ambao walikosa kuelewana na Chebukati kuhusiana na matokeo. mahakama iliweza kuwakubalia kushiriki katika kesi hii licha ya naibu ama Rais mteule Dr. William Ruto kutaka wao makamishna wanne wasikubaliwe. Unadhani kidogo hii inaweza kuwa na athari gani katika kesi hii, kuwaruhusu wale makamishna wanne kushiriki katika kesi hii?
Naam, hiyo itakuwa na inafanya kunakuwa na pande kinzani kutoka kwa tume moja ambayo pia unapata upande mmoja hautetei tume.
Ndio.
Kwa hapo awali 2013 2017 IBC imekuwa ikitoka kwa upande mmoja. Hata kama kumekuwa na taswishi kama vile tuliona 2017, bado commissioners walikuwa kwa upande wale ambao waliwakilisha IBC kotini walikuwa wanaegemea upande mmoja, ila sasa tuna makomishona ambao wote hawako kwa upande mmoja. Hilo linaweza kuwa tatizo, ila sasa tutangoje tuone namna koti itaangalia matukio kama hayo, kwa sababu hilo ni jambo la kwanza ambalo limetokea, ni mara yake ya kwanza kutokea hapa kwa hii koti ya Kenya.
Naam, katika maombi jumla karibu ya maombi zaidi ya 9 ambayo Azimio walikuwa wametaka koti iweze kuamua, na koti imeweza kujumuisha zile kesi ambazo zilikuwa 9, zikatupilia mbali 2 kama ulivyosema hapo awali, na sasa imesalia 9, na 9 hizi kesi zimewekwa pamoja hadi ikawa kesi moja. Labda tuzungumzie masuala muhimu ambayo tunatarajia tu sasa wale majaji wataweza kuja kutueleza baada ya kusikiliza kesi yenyewe. Tuanze na swala la teknolojia.
Swala la teknolojia limeibua hisia sana. Kwa hivyo la kwanza litakuwa whether hii teknolojia ambayo IBC ilitumia iliweza kuhakiki kwamba uchaguzi ni wa huru, haki na ambao kuna uwazi wa kutosha. Kuna zile tetesi kwamba server ilikuwa hacked. Sasa kama kulikuwa na mambo kama hayo, tutaweza kujua yalikuwa kiasi gani, kwa sababu hilo ni jambo ambalo lazima tuangalie.
Naam, labda tunapozungumzia tu swala la teknolojia, unadhani kwamba majaji hao wanaweza kuenda kwa kiwango gani kutaka kudhibitisha hili swala la teknolojia, kama kidogo kulikuwa na itilafu wa kimitambo?
Swala la teknolojia itategemea kwanza ni kiasi ambacho evidence ambayo imewekwa kotini ni kiasi gani, kwa sababu majaji hapa wao wanaangalia tu evidence ama ushahidi ambao wale ambao petitioners wamewakilisha. Wakishaangalia huo ushahidi, ndio sasa unawaambia kwamba tutaangalia kiasi gani. Hawawezi enda nje ya yale ambayo petitioners wameweka kotini, kwa sababu sasa hayo ndio watakuwa wanaangalia, na cha muhimu ni kwamba kama kumekuwa na taswishi ya kiteknolojia ni vipi ime affect outcome ya uchaguzi. Hilo ndilo kuu sana, kwa sababu ndio kunaweza kuwa na hitilafu huku, lakini upate kwamba
haikuwa na madhara
uchaguzi.
Na kweli tumeona hata majaji pia wameruhusu, kuna kundi fulani la wanateknolojia ambao wameruhusiwa pia kujumuisha katika kesi hii. Labda pia wao huenda wakatoa mchanga wao. Naam, tuzungumzie swala la pili, Forms 34A, kwamba upande wa Azimio unadai kwamba zile fomu ambazo zilikuwa zimewasilishwa kutoka kituo cha kupigia kura hadi kwenye tume ya IBC ni tofauti. Hili ni swala pia ambalo kidogo lina utata.
Naam. Form 34A kwa kutokana na uchaguzi za hapo awali 2017, koti ilisema kwamba na pia kesi ya Maina Kiai, koti ilisema kwamba hiyo Form 34A haifai hata kubadilishwa. Sasa kwa huu uchaguzi Form 34A ilikuwa inatangazwa kwa matokeo ya Form 34A yalikuwa yanatangazwa kwa polling station. Alafu zikikusanywa kwa constituency zinapelekwa zinafanya Form 34B. Hiyo 34B ndio sasa inaletwa Nairobi Bomas. Matokeo ya Form 34B yanatoa sasa matokeo ya Form 34C ambayo yanatumika kusema nani ndio mshindi. Kwa hivyo iwapo tetesi za teknolojia zina affect upande moja, kwa mfano koti inataka kujua zile Form 34A ambazo ziko kwa server ambazo wote tumeweza kuangalia kwa mtandao ni zile ambazo zililetwa Bomas. Hilo ndilo jambo la kwanza. Alafu pia wanafaa waangalie, je, zile fomu ambazo ziliwekwa Bomas ndizo zile ambazo maajenti haswa wa Azimio walipewa wakibainisha kwamba zote ni sawia. Kwa hivyo itakuwa imebainika kwamba labda hakukuwa na any hacking ambayo petitioners walisema.
Na labda pia uongezee tu swala la usawa ama sahihi ya ile form 34A kwamba yalikuwa na matokeo sawa, kwa sababu pia wanasema kwamba kuna madai kwamba kuna watu ambao walikuwa wanapokea, wanabadilisha, alafu wanarudisha katika ile tovuti ya IEBC.
Naam, hilo litaweza kubainishwa haswa kulingana. Sasa unajua ndio tumetumia teknolojia ila kwa ukubwa utasema kwamba bado tunatumia manual.
Ndio.
Kwa sababu yale ambayo yalikuwa kwa portal ama server hayo ndio sio hayo yalitumika. Makaratasi ambayo ama fomu ambazo zilitumika kujumuisha pale Bomas ni zile ambazo ni hard copies, zile ambazo zilitumwa kutoka kwa constituencies na returning officers. Kwa hivyo iwapo mtu alienda aka affect haya ambayo yalikuwa kwa mtandao ama the portal for the IBC ones, it must be demonstrated that hizo zili affect pia hizi hard copies, kwa sababu ndio unaweza badilisha ya IBC lakini huwezi badilisha ile ambayo returning officer amebeba akileta Nairobi. Kwa hivyo hayo ni mambo ambayo koti lazima ipeane mwelekeo sahihi. Naam.
Kuna swala la kutofanyika kwa uchaguzi wa ugavana katika maeneo mbalimbali, ambapo shughuli hiyo iliweza kufanyika jana katika kaunti ya Kakamega, kaunti ya Mombasa na maeneo bunge kama 4 hivi na maeneo ya Wadi. Kuna madai kwamba tume ya IEBC ilipoweza kukosa kufanya uchaguzi wa ugavana katika maeneo hayo, Wazimio wanasema kwamba kidogo iliathiri kura na huenda labda ikaweka wao katika nafasi ya nyuma. Kwa hivyo hili ni swala pia ambalo nimeona limeorodheshwa katika masuala ambayo majaji wanaweza kutambua. Labda ulizungumzie hili swala kidogo.
Hilo kwa sasa ni mara ya kwanza koti imepata jambo kama hilo hasa kwa uchaguzi wa urais. Kwa hivyo itakuwa muhimu kwa sababu tutaangalia, koti itaangalia kwamba hata kama kulikuwa na athari ilikuwa pia kiasi gani, kwa sababu ndio kabla ya huu uchaguzi kumekuwa na baadhi ya uchaguzi ambao bado umehairishwa. Hii sio mara ya kwanza koti kuhairisha uchaguzi, yani IBC kuhairisha uchaguzi maeneo fulani. Ila sasa jambo la kushangaza, labda jambo ambalo koti itataka kuangalia saa hizi ni kwamba je, ilikuwa tu kwa ngome za Azimio na unaona pia kuna kesi moja labda Rongai, hizo pia zitatumika kuonyesha kwamba je, kulikuwa na sehemu moja tu ambayo waliegemea sehemu moja kuhairisha, na pia hata kama walihairisha ni uchaguzi tu mmoja wa governor, sio kwamba ilikuwa uchaguzi wote. Kulikuwa na uchaguzi wa wodi, mbunge, senator na pia mwakilishi wa kina mama. Huo wote hizo uchaguzi zote ziliendelea. Kwa hivyo itakuwa muhimu kuangalia, je, hii ya governor ili affect general outcome ama haiku affect general outcome. Kwa hivyo hiyo itategemea vipi petitioners wataweka ushahidi wao, ndio koti itaweza kupeana mwelekeo kwa hilo jambo.
Alafu hili ni swala kidogo ambalo alijaweza kushuhudiwa katika chaguzi za mwanzo. Kwa hivyo kuna wale ambao wanahoji kwamba uamuzi wowote ambao utatolewa na majaji utaweza kutumika kisheria humu nchini, kwamba iwapo kuna hali ambapo uchaguzi umeahirishwa katika maeneo fulani, tume itaweza kufanya vipi?
Kabisa, kwa sababu itakuwa muhimu tujue kiasi gani. Kwa mfano, kabla ya huu uchaguzi kuna maeneo ambao wamehairisha, labda wamehairisha mbunge, wamehairisha ya mwakilishi wa wadi, ndio ambayo hayajafikishwa kwa mahakama. Labda tumeona kwamba hiyo ni hitilafu ya kawaida. Lakini kwa sasa lazima mahakama ijaribu kuweka vipimo ambavyo vitatumika kuangalia ni kiwango gani ambacho kitaharibu uchaguzi wa rais, ama ni kiwango gani ambacho tutasema hiyo labda ilikuwa kosa la kawaida.
Naam, mawakili wa Azimio wanasema kwamba kulikuwa na idadi kubwa sana ya watu ambao waliweza kujitokeza katika maeneo ya kupiga kura, na walipofika pale wakapigia kura tu rais, lakini hawakupiga kura kwa wale viongozi wengine kuanzia seneta hadi mwakilishi wa wadi. Hili ni swala ambalo pia nimeona kidogo linazua uzito.
Naam, hilo pia ni baadhi ya mambo ambayo koti imesema lazima itapeana uamuzi kuhusu. Kwa hivyo hilo haswa itabidi koti iangalie kwa ujumla. Iwapo watu ambao walifika kotini ni wengi sana, wale ambao walipiga kura ya urais ni wengi sana kuliko wale ambao wamepigia viti vingine, basi hilo linaweza kuwa sababu muhimu sana ya kuangalia kama uchaguzi ulikuwa wa wazi. Ila unaweza pata kwamba nambari sio kubwa sana. Wakati ambao nambari sio kubwa sana, kwa mfano watu labda idadi chache 50, hizo ni tofauti ambazo zinaweza kuwa, it's possible, hizo zinaweza kuwa, na koti haiwezi batilisha kwa sababu ya hizo tofauti ndogo. Zikiwa kubwa, koti labda itaangalia sana, hasa ukizingatia kwa mfano uchaguzi wa mwaka wa 2007 ambao tofauti zilikuwa kubwa sana ila haukufika kotini. Kwa hivyo hatuwezi.
Alafu pia pale kuna hili swala la iwapo unapiga kura alafu ukakosea kupiga kura, ile kura yako ikatupiliwa mbali ama ikawa ile rejected vote. Kwa hivyo hii inakwenda katika takwimu za kuonyesha ni kura ambazo zilipigwa kwa jumla.
Hapo awali koti imesema kwamba hiyo haitaenda kwa takwimu. 2013 na 2017 koti ilipeana huo mwelekeo. Kwa hivyo wakati ambao IBC ilikuwa inaenda pia kwa uchaguzi, ilikuwa inatumia mwelekeo wa koti. Sasa saa hizi haijawekwa kama moja ya zile issues ambazo koti itakuwa inaamua, ila najua hapo katikati lazima litazungumziwa kwa kina. Kwa hivyo koti inaweza shikilia mwelekeo ambao ilikuwa imepeana hapo awali, ama pia koti inaweza amua kubatilisha mwelekeo wake, na ikibatilisha itaeleza sababu ambazo zilifanya ikachukua mtazamo mwingine. Sababu hii koti ya upeo ama the Supreme Court lazima iko na uhuru wa kubatilisha uamuzi wake wa awali, yani mtazamo wake wa awali. Inaweza badilisha mtazamo wake wa awali, sio kama koti zingine labda za tuseme mahakama kuu ambazo zinafuata mwelekeo wa koti ya upeo. Hiyo ni Supreme Court.
Naam, labda tu tuzungumzie hili swala la IBC kutathmini, kuhakikisha kwamba matokeo ambayo wamepokea kabla kutangaza ni sawa. Ni swala pia ambalo limeweza kuibuliwa hapa na imeonekana kidogo kuna makamishna ambao wanasema kwamba matokeo ambayo yalitangazwa na Chebukati hayakuweza kutathminiwa ipasavyo. Hili ni swala pia ambalo huenda labda tukatarajia kusikiza mengi zaidi kuhusiana nalo.
Naam, hilo lazima ni jambo ambalo lazima tuangalie, IBC angalie, lazima koti angalie kwa makini, kwa sababu unapata kuwa iwapo kutakuwa na hiyo idadi haziingiani sawa, hiyo ya tallying, lazima sasa koti iseme labda hatukufika 50+1. Kumbuka kwamba ni jambo ambalo 50+1 kwa hii uchaguzi ni kura chache sana. Haikuwa uchaguzi ambao watu wameachana na kura nyingi sana. Gap ilikuwa kidogo. Kwa hivyo hilo litakuwa jambo la maana sana, na iwapo itabainika kwamba hiyo process ya kuverify haikukuwa ya uwazi, basi kunaweza kuwa na sababu labda ya kuamua kwamba uchaguzi haukuwa wa haki. Ila pia ikibainika kwamba, kwa sababu mara nyingi Bomas kulikuwa na at least verification, especially kwa maagenti walifanya kazi, na pale mwisho ndio tuliona tatizo kubwa hiki. Iwapo watabaini kwamba hapo awali constituency zote hizi form 34B ziliweza kukaguliwa, hilo basi itakuwa imebainisha kwamba uchaguzi ulikuwa verifiable na ulikuwa ambao watu wange verify matokeo.
Umezungumzia hapo awali pia swala la mshindi kupata 50% na kura moja. Ikiwa labda naibu ama rais mteule William Ruto aliweza kupata 50% ya kura 50 zilizopigwa na kura moja. Ili majaji kuweza kudhibitisha hili swala, itakuwaje sasa? Watafanya tena upya kuhesabu kura?
Hawawezi kuhesabu kura upya. Hilo tuliona kwa mfano Bomas. Ilichukua muda sana kuhesabu hizo kura kutoka kwa form 34. Hata Bomas walikuwa wanatumia form 34B. Sasa iwapo watu watataka kuhakikisha kwamba kura ilikuwa ya kuhesabu tena, itabidi umeanzia form 34A. Form 34A ni nyingi, karibia zimefika 46,000. Hizo kwa huu muda ambao koti imepewa ni chache, muda ni kidogo sana. Hatuwezi weza fanya recount unless pia iwe kwamba maeneo, labda kwa maeneo tu, ikibidi sana labda eneo moja koti inaweza sema hiyo kituo kimoja kiangaliwe tena.
Tulikuwa tumeweza kuona Azimio walipoleta kesi hii, waliweza kuleta makaratasi ikiwa kwenye gari kubwa sana, na baadaye wakaweza kufupisha, wakasema kwamba kwa sababu ya muda wameweza kukutanisha ushahidi wao katika kurasa tu 30. Muda ambao umetengwa kwa majaji wa mahakama ya upeo kuweza kusikiliza kesi hii ni siku 14, na kati ya hizi siku 14 tayari tunaona kama 7 imekwenda. Kwa hivyo sijui kwa maoni yako, labda tu unaona kwamba kuna haja labda ya kuangalia upya sheria hii, ama kwako ni sawa?
Kwangu ni sawa, ndio inategemea, yani tunaweza sema ni sawa kwa sababu pia tunataka uwezo uwe ambao tutafanya uchaguzi na tumalize tuendelee. Kwa mfano ukiangalia nchi saizi kila mtu anaangalia Supreme Court iweze kupeana uamuzi. Iwapo haitapeana uamuzi kwa hizo siku ambazo zimetengwa, inamaanisha kwamba hata biashara ama shughuli zingine hazitaendelea ipasavyo. Kwa hivyo ni vyema muda unafaa ufupishwe. Ila pia ukiangalia sasa kutokana na kisheria utasema mtu anafaa apewe haki ya kuweka ushahidi wake wote kotini na ushahidi wake wote uweze kutiliwa manani. Sasa unapata kwamba ni competing interest. Whether tunafaa tumalize within time ama pia tunafaa tupe kila mtu muda wa kutosha akuja wakilishe kesi. Ila ukijaribu sasa kuangalia hizo pande mbili competing interest, then unaona ndio hizi siku 14 ziko sawa, ama saa zingine utapata kuna wale ambao wanaona labda tuongezewe zikuwe 15, 20, ila hata zikiwa 20 bado koti haiwezi, utapata kwamba koti haitaweza kuangalia karatasi zote ama watu wasipofupisha yale ambao wanaweka kotini, koti haiwezi zingatia. Na kama kwa mfano mkutano wa leo hiyo inaitwa pre-trial conference, umeweza tena kuangalia hizi 40 pages ama hizo pages zote ambazo walikuwa wamesubmit, imeweza sasa kuainisha issues 7, angalau 7 ambazo itatilia manani zaidi. Sasa unapata kwamba ndio ni muhimu koti ipunguze yale ambayo itaamua. Haiwezi chukua mambo mengi sana kwa muda wa siku 7. Na pia sisi tunaweza taka kuweka kila kitu ambayo tuko nayo kotini kubainisha kwamba uchaguzi ulikuwa wazi. So hiyo labda labda kuna haja iongezwe siku 2-3, ila bado ni vizuri sana siku ziwe chache, tusiwe na siku refu.
Labda tu tukimalizia Bwana Moroga, tuangazie kidogo maombi ambayo yameweza upande wa Azimio unasema kwamba unataka upewe. Licha ya kusema kwamba wanataka ushindi wa William Ruto uweze kutupiliwa mbali, Azimio pia wanasema kwamba wanataka mahakama ya upeo iweze kupata kwamba tume ya IBC haina uwezo wa kuandaa uchaguzi sawa na ulio wazi, na bado pia wanasema kwamba wangetaka majaji hawa kumpata Bwana Chebukati kama hayupo sawa kuwa katika ile afisi. Hayo maombi kidogo yanaonekana kukinzana, ama unaona vipi? Na unadhani majaji wanaweza kutoa maombi kama hayo?
Hayo sasa hatuwezi enda sana kwa kuona kama merits kama jaji wanaweza peana ama hawawezi peana, ila tunaweza tu angalia kwamba kuna kukinzana, kwa sababu leo kama koti imeamua kwamba IBC haiwezi fanya uchaguzi wa huru na haki, haiwezi tena tangaza mtu kwamba ameshinda kutokana na uchaguzi wa IBC. Na pia vile kutoa mtu kama Chebukati, huyo ameteuliwa na anasimamia tume huru na haki. Kuna procedure ambayo imewekwa hapo. Kwa hivyo hata koti labda ikiangalia hilo swala, inaweza tusema kwamba kuwe na further investigation. Kwa sababu saa hizi koti haitatui suitability ya Chebukati.
Lakini tumeona katika uamuzi wapo awali tumeona mahakama ya upeo ikiweza kupendekeza kufanyika uchunguzi, kufanyike hili na hili, lakini pindi tu baada ya majaji hawa mahakama ya upeo kutoa uamuzi wao, mambo yanakwisha, hakuna uchunguzi wote unafanywa.
Naam, huo ni ukweli, kwa sababu sasa hapo labda ndio tunafaa tukiangalia hizi uchaguzi tusilaumu tu IBC. kwa sababu koti ikishapeana 2013 kulikuwa na koti ilisema kwamba waangalie teknolojia ambayo ilitumika. 2017 pia kulikuwa na mapendekezo ya koti kwamba idara husika ziweze kufanya uchunguzi. Huo bado haujawahi afanyika hadi wa leo. Kwa hivyo hata wakati ambapo sasa tunaangalia hapa, kuna uwezekano kwamba koti itapeana mwelekeo. Tutasema kwamba recommendations kwamba kuwe na further investigations kubaini nani labda aliharibu uchaguzi ama kama kuna mtu ambaye anaweza funguliwa kesi. Sasa itategemea na kama serikali ya siku kama itataka kuangalia hayo masuala zaidi, tutaweza kujua uwazi zaidi.
Shukran sana. Mtazamaji, tumekuwa naye wakili Dennis Moroga ambaye ni mhadhiri katika chuo kikuu cha Moi, akiweza kutupa tu changanuzi wa masuala yanavyotukia katika mahakama ya upeo, ambapo ni siku ya mwanzo ambapo kikao kimeweza kufanyika hapo awali mwendo wa saa 5 na kukamilika takriban saa 1 iliyopita, ambapo wale wote wanaoshiriki katika kesi hii wameweza kuketi pamoja na kupiga tu darubini na kutathmini kesi, kuweza kutenga muda kwamba IEBC wamepewa muda wa saa 3 kuweza kutetea ushindi wa William Ruto kama rais mteule. Alafu pia upande wa Ruto wamepewa pia saa 3 waweze pia kuwasilisha kesi yao ama majibu yao. Alafu pia upande wa Azimio wameweza kupewa muda sawia na huo wa saa 3. Kwa hivyo mtazamaji, kwa sasa majaji wote 7 wamekwenda kwenye mapumziko ili kuweza kutathmini na kuweza kutoa uamuzi kuhusiana na masuala mbalimbali ambayo yaliweza kuibuka. Na swala moja ambalo majaji watakuja tu kutoa uamuzi ni kuhusiana na uwakilishi wa tume ya IEBC, ambapo Githu Muigai anasema kwamba yeye ndiye anawakilisha tume ya IEBC. Lakini pale tumeona kwamba kuna makamishina 4 kina Cherera pamoja na Justus Nyang'aya ambao wana mawakili wao ambao ni Paul Muite na Isa Mansu. Kwa hivyo upande wa mahakama itabidi uweze kutoa mwelekeo kuhusiana na swala hilo. Alafu pia kuna wale mawakili ambao walisema kwamba hawajaweza kupeana majibu yao kwa sababu waliweza kupata makaratasi jana mwendo wa saa 2 usiku, saa 3, na hawajapata muda wa kuweza kuwasilisha majibu yao. Kwa hivyo pia mahakama itakuwa inaweza kutoa uamuzi wake kuhusiana na swala hilo. Mtazamaji, bado tu tumepiga kambi hapa katika mahakama ya Milimani kufuatilia swala hili kwa karibu. Ni swala ambalo litaendelea hadi siku ya Ijumaa, na majaji watakwenda kupumzika siku ya Jumamosi na Jumapili, ili siku ya Jumatatu basi waje wazi na kuambia Wakenya ukweli jinsi mambo yatakavyokuwa yametukia. Mimi sina la ziada, nikiwa na mwenzangu hapa wakili Dennis Moroga. Narudisha matangazo haya hapo studio kwako BenTroy Njue, tutarejea hapo baadaye.
Shukran sana mwenzangu Ben Chumba, Sarafina Robi na pia mhakiki huyo mlienaye hapo studio. Mpya pia tumetengeza hapo kidogo, lakini itaweza kushikilia haya maneno. Shukran sana kwa pia hayo yote mmeweza kupitia. Allow me, Chumba, now to switch to English. And talking about the Supreme Court case, they have consolidated or collapsed the 7 petitions that were left into one. Now it's official, baptized it the Raila Odinga Martha Karua petition. And speaking of that, that's where we begin our live coverage. As you can see behind me, it's time for our lunchtime news, and we're going to be focusing also on matters election after now we have governor-elect in Mombasa and also in Kakamega. But first things first, my name is BenTroy Njue, and Lensa Odingo will be our sign language interpreter for this live newscast. We begin at the Supreme Court, where the court will have 9 key issues to determine in the presidential petition filed by Azimio leader Raila Odinga. Some of the issues are whether the technology deployed by Independent Electoral and Boundaries Commission met the standards of integrity, verifiability, transparency, among others.
The presidential petition pre-trial conference seeking to challenge the election of William Ruto as president-elect kicked off on Tuesday, with the court seeking to consolidate all issues raised to match the strict timelines.
After we dealt with the preliminaries, 2 petitions were struck out.
Among the issues the court seeks to determine are whether the technology deployed by IEBC met standards of integrity, verifiability and transparency to guarantee credibility of results, whether there was interference of Form 34As from the polling station to the IEBC portal, whether there were differences between Form 34A on the portal, Form 34A at the National Tallying Centre, and Form 34A with the agents at the polling station, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheliba, Rongai and Pokot South constituencies and electoral wards resulted in voter suppression to the detriment of the petitioners, whether there were unexplainable discrepancies between votes cast for the presidential candidates and other elective positions, whether IEBC carried out its mandate in accordance with the law, whether the president-elect got 50% plus one of all votes cast, whether there were irregularities and illegalities of such magnitude to affect the final result of the presidential election, and what reliefs and orders can the court grant or issue. The court has until Monday, the 5th of September, to deliver a verdict. Nancy Okware, Lunchtime News.
And away from the Supreme Court, let's now cross over to Kakamega County, which has a governor-elect, Fernandez Baraza of ODM. But for more, including how the other candidates performed, let's first of all cross over there. I can see Achola Simon is standing by with the latest news from Kakamega County. Achola, over to you.
Fantastic, BenTroy, Njue, indeed. Fernandez Baraza is the governor-elect of Kakamega County, of course, after having garnered 192,929 votes from a possible 844,351. His closest competitor, who is Cleophas Malala of ANC, managed 159,508. Of course, there were a number of other aspirants, including seasoned politician Cyrus Jirongo, Michael Osundwa, and among others who actually also were going for the seat. But the two, Cleophas Malala and Fernandez Baraza, were the front runners for this particular seat. And Fernandez Baraza emerging victorious in this fierce battle that, of course, had been postponed not once but twice by IEBC, citing various reasons. Of course, the first one being the technicalities that involved the printing of the ballot papers, and of course the second one, of course, what IEBC had raised in terms of intimidation and the security of IEBC officials. But finally, Kakamega County, one of the most populous county in the country, finally gets their governor, and it's just a matter of time before, of course, the ball sets in motion in terms of service delivery for the people of Kakamega County. Troy, just a few minutes ago, before we came for this live broadcast, various leaders from the Azimio La Umoja coalition had actually gathered at this very point, and they were actually addressing enthusiastic supporters who had actually come all the way from Kakamega High School, snaking through Kakamega town in jubilation over this very good victory for them. And of course, their narrative revolving around how hard they've actually fought to ensure that they rescued this victory from the jaws of Kenya Kwanza coalition. But they're also saying that this is a clear indication that the Azimio La Umoja coalition, and more specifically Raila Amolo Odinga, still commands some level of support from this particular region. They also, of course, as expected, says that this will, of course, come in the good stead in terms of what will be happening or what is actually going on in Supreme Court. And of course, this will give them that necessary impetus in terms of waiting what will happen at the Supreme Court finally on the 5th of September. But Troy, what I will also just add is the fact that Cleophas Malala has already conceded defeat. He actually extended an olive branch to the governor-elect Fernandez Baraza, and he has actually said that he was willing to actually work with Fernandez Baraza in terms of ensuring that some excerpts from his manifesto are actually borrowed in terms of ensuring that they move forward the development agenda of Kakamega County. Fernandez Baraza also also in his speech did extend an olive branch to his competitors, saying that he is willing to ensure that they actually work with all leaders from this particular region so that then they can actually move the development agenda of Kakamega County forward. Each and every leader who actually spoke hailed the competition as free and fair, regardless of the fact that, of course, yesterday we did mention quite a number of times that there were incidences of voter bribery and, of course, the failure of Kim's kit in certain polling stations. However, the unanimous decision here has been the fact that all leaders are actually impressed with the manner in which IEBC has actually carried out this election in Kakamega County. In fact, at some point, Wycliffe Ambeso Oparanya, the outgoing governor, did joke that he is very impressed with how the Kakamega branch of IEBC managed this particular election. But of course, we understand that IEBC is just one and the same. The other thing that leaders have actually continuously mentioned has been the need for the leader who is actually coming in, and of course this will greatly help that agenda to continue with the legacy that has actually been put in place by Wycliffe Ambeso Oparanya in terms of the development agenda. And we know for a fact that having elected a leader who comes from the Azimio la Umoja, and more specifically ODM party, that leader that of course the agenda that has actually been set on the foundation that has actually been set by Wycliffe Ambeso Oparanya will actually be enhanced, if not completed. Back to you, BenTroy, Njue.
Indeed, Kakamega now has a new governor, and it's a good thing that the leaders have embraced and even congratulated Fernandez. What is the mood there? I can see people are continuing with the everyday today. Okay. Thank you, Achola. Of course, we will be coming up with much more in regards to that election. And still on matters touching on polls, Paul Chebor of the United Democratic Alliance Party has been elected as Member of Parliament for Rongai constituency. Chebor beat the incumbent Raymond Moi of the KANU party, with Chama cha Mashinani's Luka Kigen coming in at a distant third. Our senior political journalist Gishoke Washira has the details on the parliamentary poll.
The outgoing Solai Ward MCA is the incoming member of National Assembly for Rongai constituency. Paul Chebor, flying the UDA ticket, ousted former President Daniel Moi's son Raymond Moi, who had served for 2 terms in the August House.
The constituency returning officer, Rongai constituency hereby declares that Paul Kibet Chebor of ID number 12935586 has been duly elected as a member of the National Assembly for Rongai constituency in the election held on 29th day of August 2022. Dated this day of August 2022. Congratulations.
The UDA candidate Paul Chebor got 27,021 votes, while incumbent Raymond Moi of KANU garnered 14,715 votes. Former MP Luka Kigen, running on Chama cha Mashinani party, got 593 votes. The race attracted a voter turnout of 50.2%.
Hii uchaguzi tumetoka mbali, tuavyo tangu nominations, tulirudia kura ya nomination mara 2, tena hii tumearishwa mara 3. Kwa hivyo nataka kusema ya kwamba tuko na ushindi siku ya leo kama UDA na kama watu ya Rongai. Nataka kushukuru watu wote wale walipigia kura, hata wale hawakunipigia kwa sababu tuwazalendo competition, na washukuru sana. Mungu awabariki. Basi sasa tuanze kazi, kusaidia wananchi na kusaidia watu ya Rongai.
Gishoke Washira, Lunchtime News.
And still on elections, the mini polls conducted yesterday, David Mwalika of Wiper Party successfully retained his seat as Kitui Rural Member of National Assembly after garnering 19,745 votes out of the 30,089 cast votes in the constituency. He beat his opponent, Charles Nyamai, a former MP, was vying under a UDA ticket. Nyamai garnered 10,178 votes.
I, the constituency returning officer, hereby declare that David Mwalika Mboni of ID number 44-15-798 has been duly elected as a member of National Assembly for Kitui constituency.
It was a joyous moment for David Mwalika, who was re-elected as Kitui Rural Member of National Assembly. Mwalika, who was vying under a wiper ticket, garnered 19,745 votes out of 30,089 cast votes in the constituency. He beat his opponent Charles Nyamai, a former MP who was vying under a UDA ticket. Nyamai garnered 10,178 votes. 166 votes were rejected by the returning officer Winfred Ndoti. Joyous Mwikali promised to work to deliver his manifesto to the members of his constituency.
But I want to assure the people of Kitui Rural are going to serve them better than the last 5 years.
Mwalika will now be serving as a member of National Assembly for the second term after he beat Nyamai in 2017 general elections. Kitui Rural constituency, which was established and gazetted in 2012 by IEBC, has 55,000 registered voters. It is one of the 8 constituencies of Kitui County. Reporting for Lunchtime News, I am Elvis Otieno.
And away from matters elections, thousands of residents in Kajiado County are staring at starvation following a prolonged drought that has decimated livestock and vegetation. The situation has further been compounded by the effects of the COVID-19 pandemic. More than 1 million cattle are also at the risk of starvation and require urgent feed and water. The residents are now urging the national and county governments to upscale relief efforts.
According to the county's recent survey, at least 450,000 heads of cattle valued at approximately 13.6 billion shillings are on the verge of death, with 75% of wildlife affected and dying of hunger. The county government has set aside 130 million shillings from the emergency kit to be supplemented by the cash transfer program by the national government.
Together with the national government and other players, we will go out of our way to make sure that no lives are lost for the people and to try as much as possible to mitigate the losses from their livestock.
To help prevent the rising cases of deaths among people and livestock, short-term measures have been implemented, including providing relief food to the affected communities. The government has further enhanced livestock vaccination in affected areas. A large number of herders have crossed to Tanzania in search of pasture. The worst affected areas are Poka, Imbirikani, Purko, Maparasha, Shompole, Mosiro, Mile 46, Meto, Ildamat Mailwa, Lenkisim, Kitengela West, and Isinya. For Lunchtime News, I'm Juliet Njoroge.
Let's now shift focus to matters education, where parents at Mitero Primary School in Laikipia Central have withdrawn their pupils from the school, citing mismanagement by the school's administration. The parents, who held a peaceful demonstration at the school, accused the headmaster of running the school single-handedly, as well as embezzling funds meant for development.
The angry parents who took to the streets in protest accused the headmaster for colluding with a section of parents who he had appointed as the board to withdraw funds from the main bank account. They have now called for immediate transfer of the headmaster and the new board elected.
Tumeenda katika Teachers Service Commission kule na Yuki, kwa maana tulikolea pesa hapa shilingi 25,000 ilikuwa ya project ya kutengeneza loka, lakini wakati tuliuliza hiyo pesa kwake ikawa ni vita kwetu, hatitaki kutuona ama kutuongelesha.
Head teacher amekuwa ghost worker in Mitero Primary School, huwa hapatikani hata kidogo. Ofisi imefungwa, deputy naye ameresign. Kwa hivyo hakuna head teacher, hakuna deputy. Deputy ni kulitaya ameretire. So the two offices are always closed. Haya, kwa walimu we have only 5 teachers in Metero.
One of the suppliers who has not been paid his dues since 2020 has threatened to auction some of the school property to get his funds.
Pota ile board yote ilikuwa kwa hii shule haijui. Na tayari wakileta hii barua wakipeana walikuwa amesema atakuja kuokchonia kama ni hii matagi ya shule. Sasa ile swali tuko nayo kwa Bwana Anthony. Tunataka adhibitishe walichukua hii deni na nani na alipeleka wapi, lakini hii deni sio ya shule ya Metero.
Efforts to reach the headmaster and TSC officials were futile.
Let's now refocus on the yesterday's mini polls where Frederick Mubichi of United Democratic Alliance has clinched the Njue West ward seat in Meru County after garnering 2,026 votes. In Nairobi's Embakasi South constituency, independent candidate Francis Kiragu got 2,098 votes to win the Kwanjenga ward MCA seat.
The United Democratic Alliance has clinched the Njue West ward seat in Meru after its candidate Frederick Mubichi garnered 2,026 votes. Followed closely with 1,976 votes, while Hilary Mugambi had 1,968 votes. Independent candidate Joseph Moria garnered 1,944 votes. Speaking after being declared the winner, Mubichi called on his opponents to support him.
Wenye tulikuwa tunashindana na wao, pia nimewashukuru kwa sababu tumekuwa na mashindano yenye ilikuwa na nidhamu na kampeni zetu, na hiyo safari yote tumeenda yenye nafaa na hatujai kuwa na vita, hatujai kuwa na shida yote, na Mungu awabariki na tutaendelea kufanya kazi pamoja.
In Nairobi's Embakasi South, independent candidate Francis Kiragu got 2,098 votes to win the Kwanjenga ward MCA seat. Francisca Kwamboka of UDA came second with 1,344 votes.
The people of Kwanjenga have spoken on their own without depending on a political party, neither on a tribal line. And we are more than ready to work as a team. To my fellow competitors, it was a fair game.
Elections in the two areas were among the 8 postponed on August 9th.
Let's now make sense of shillings and percentages. Family Bank made 1.6 billion shillings in net profit during the first 6 months of this year, representing 37.4% year-on-year growth. Family Bank CEO Rebecca Mbidi attributes the profit growth to a 24% growth in net interest income, while total non-interest income rose 21.3%.
During the first 6 months of this year, Family Bank Group committed 75.6 billion shillings in net loans and advances, representing a 19.3% year-on-year growth. From these, Family Bank made 4.62 billion shillings in interest income, representing a 15.9% year-on-year growth. In addition, the lender's total investment in government securities increased by 28.5% from 19.36 billion shillings to 24.89 billion shillings. Family Bank made 1.47 billion shillings in interest income from government securities, representing 55.2%. The lender also booked 39.76 million shillings in interest income and deposits in other banking institutions, pushing the total interest income up 24.1% to 6.13 billion shillings. During the period, Family Bank booked 1.85 billion shillings in total non-income interest, representing a 21.3% year-on-year growth. On the other hand, the total operating expenses marginally increased from 3.58 billion shillings to 3.61 billion shillings. The stock of gross non-performing loans and advances marginally increased from 10.8 billion shillings to 11.78 billion shillings. This saw the lender reduce the loan loss provision by 41.7% to 358 million shillings. However, the net non-performing loans exposure increased 46.1% from 505 million shillings to 738 million shillings. Despite the 37.4% increase in net profit, Family Bank's earning per share reduced from 83 cents to 56 cents per share on account of deterioration of fair value changes in available for sale financial assets from negative 101 million shillings to negative 889 million shillings. This pushed down the lender's comprehensive income for the period from 1.07 billion shillings to 723 million shillings. Reporting for Lunchtime News, I am Teresa Mutai.
Elsewhere, the government is urging the youth to take advantage of the Ajira digital program to boost their ICT skills for employment. According to the Ministry of ICT, Innovation and Youth Affairs, the program ultimate goal is to create value for businesses and boost digital opportunities for Kenyans.
Tech skills will in the future be a prerequisite for employability. This is according to a report by Mercy Corps, which predicts that by the year 2030, about 55% of all jobs in Kenya will require digital skills.
We have shifted. Technology has shown us that Karioko now can be found in a global map, and therefore we are actually operating in a global space.
The national study on the digital economy indicates that about 1.2 million young people are making a living through digital and digitally enabled jobs.
We've said we want to train 20 million Kenyans on technology. We've said we want to train 300,000 civil servants, and we're going to use 10,000 professionals to do that training.
While the shift in the job market would see increased opportunities for the youth, a majority of them lack the requisite skills. The government is urging the youth to take advantage of the Ajira digital program to boost their ICT skills to tap increased internet connectivity that is currently more than 40% of the population.
So someone in a remote location is able to travel to another using even virtual reality because they have the connectivity in place. And then it will put us at par with the rest of the world, because when you want to innovate, when you want to do better things, you have access to the content, you have access to the information, and of course all the other things that come with having access to the internet. So it's an important part. It's communication.
To date, over 200 Ajira Youth Empowerment Centers have been rolled out across the country. Over 40 Ajira digital clubs established, universities and TVET institutions, and more than 200,000 youth registered on the Ajira portal. Now, in the famous words of writer Stuart Brand, that if technology rolls you over and you are not part of the stream roller, then you are the road. It equally means that to unlock the issue that is youth unemployment, there is need to acquire the tech skills, for the future is digital. I'm Regina Manyara, you're watching KBC Lunchtime News.
Thanks, Ray, for that report. Elsewhere, tea traders are calling on the government to reconsider the mandatory use of Integrated Customs Management System, ICMS, in clearing tea from neighboring countries and those from export promotion zones. The East African Tea Traders Association say members have been forced to pay for delayed shipments, which is affecting trading at the Mombasa tea auction.
About 25% of tea traded at the Mombasa tea auction is from Uganda, Rwanda, Burundi and Tanzania, but traders say this might reduce considerably in the next few months due to delays in clearing tea from the neighboring countries. Traders say the delays in clearing tea is as a result of Kenya's implementation of the Integrated Customs Management System to clear green leaf from the export processing zones in the neighboring countries. Tea traders say it now takes at least 2 weeks for tea from Uganda, Rwanda, Burundi and Tanzania to be cleared at the port of Mombasa, forcing them to refund for green leaf that had already been paid for. The East African Tea Traders Association says this has seen the warehouse at the port of Mombasa full with tea from neighboring countries due to the slow clearance at the expense of Kenyan tea. The tea traders warn that the situation will see Kenyan tea miss out on markets due to lack of storage and delayed shipments. Tea traders are now asking the government to reconsider subjecting the non-Kenyan tea and those from the export promotion zones to new customs system that is threatening a diplomatic standoff between Kenya and her neighboring countries. The Mombasa tea auction handles tea from 12 African countries. Njue reporting for Lunchtime News.
And from tea trading to the money market, where the Capital Markets Authority has approved the rollout of Chum's mobile application following successful testing of the product. The app, developed by Moneto Ventures, enables customers to save and invest towards a specific goal from as low as 5 shillings. This and more in our today's corporate briefs.
Last year, Capital Markets Authority admitted Chum's app, built by Moneto Ventures Limited and Coa Save Africa Limited, into the regulatory sandbox for live testing of the innovations. Following successful testing, Capital Markets Authority has today announced the exit of Moneto Ventures Limited from the regulatory sandbox, which will pave way for the rollout of the mobile application dubbed Chum's app to the mass market. CMA Chief Executive Officer Wycliffe Shamaya says the app facilitates CMA's mandate of promoting a high level of savings and investments from retail investors and enhances investments to support economic development. Chum's app functions as a collective investment scheme, CSI, an intermediary service platform that enables investors to save and invest towards a specific goal with as low as 5 shillings. Investors can withdraw their savings at any time through their mobile phones. Moneto Ventures Limited becomes the 6th firm to exit after Pesesha Africa Limited, Genghis Capital Limited, Innova Limited, Central Depository and Settlement Corporation, and the Forefront Management Limited. Meanwhile, the Competition Authority of Kenya has approved the acquisition of sole control of Coast Cables Limited by Altul Shah unconditionally. Coast Cables manufactures and imports electric cables. The company's combined revenue for the preceding year was over 1 billion shillings. CAK says the transaction met the threshold for monetary notification and full merger analysis as provided in the Competition General Rules 2019. Caroline Jenga for Lunchtime News.
And on that note, we are taking a quick commercial break. When we come back, we still have more news, including sports news. Don't go away.
Good boys gone bad.
Eric Omondi has evolved from being a comedian to now being the king of clout chasing.
How does a gospel artist make money? Jaguar wept again.
Anaweza kuwa celeb, anaweza kuwa na followers, but it's a time for artists to make bank.
Right? How is your relationship with Zari, considering that she dates young?
These are accessories.
They get out of set. Slap the guy.
Yo, what's up? My name is Ted Desire.
Oh, mashallah.
You sing about serious issues, it will not trend. If you sing about Abiambosi.
No.
Bahati hata kuwa na machozi. Willy Paul ndo alikuwa anatoa machozi.
For your beat these boys with stones. That's all be logic. Yesu ashukangi chini analeta pesa.
Musicians are missing the point.
Do we sip water?
You are watching Pop Culture with Adhiambo with a Y.
Stop! You're not authorized to enter the Princess Palace.
I need to see the prince. Lady Lily is in labor. I need you to send the doctor now.
Your son didn't survive. Please spare me.
But he killed our baby.
What now? My king, it's not true.
Hear that? The baby's been born. She gave birth to a boy?
Yes, my lady.
Kupata Zaburi 18 mstari wa pili, dial *811 *817#. Mwenyezi Mungu ni mwamba wangu, ngome yangu na mkombozi wangu. Mungu wangu, mwamba wangu ninayemkimbilia ninapohitaji kuwa salama. Zaburi 18 mstari wa pili. Zaburi 18 mstari wa pili. Dial star 811 star 817 hash. Star 811 star 817 hash.
Welcome back, and indeed we are grateful for your watching. Moving on, housing finance has swung into profitability, posting a 62.3% profit in the first year period to June this year. The mortgage says profit before tax was up 62.3 million in the first half of 2022, a 120% growth from a loss of 318.1 in June 2021. The lender says net interest income grew to 1 billion shillings, which is an 11% growth. The bank has been facing headwinds in the last 2 years due to the slow uptake of housing units occasioned by the COVID-19 pandemic.
Housing Finance Group Chief Executive Officer Robert Kibara attributed the enhanced performance to the turnaround strategy focused on a diversified business model and robust risk management framework. Non-performing loans portfolio reduced by 11% on the back of aggressive credit quality initiatives. This paved way for an asset reallocation phase that has seen the yield on interest-earning assets increase by 30 basis points, resulting in an 11% rise in net interest income.
Seen over the first half of the year is first of all strong income growth. So our total income has grown by 22%, driven primarily by growth in NFI, 54%. And also we have seen net interest income go up by 11%.
The lender has instituted a new revenue frontier in project management, which has pushed up the growth of other income by 131 million Kenya shillings, a 92% rise. New revenue streams are projected to sustain the group's profit trajectory going forward.
Also seen a reduction in costs while we continue to deploy our costs from non-productive areas to productive areas. We have also seen a reduction in overall cost as we continue to manage our expenses. That reduction was by 7%.
Total operating income grew by 22%, while operating expenses eased by 7%. Similarly, the cost of retail deposits dropped from 4.0% in June 2021 to 3.8% in June 2022. Total deposits are up by 1.5 billion shillings year on year. Housing Finance Group is an asset-rich financial services provider licensed by the Central Bank of Kenya to provide banking solutions through its subsidiary HFC. Ndutamo Kami for Lunchtime News.
And moving on, new generation smart number plates will be rolled out in Kenya in 18 months in efforts to tackle counterfeits. Making the announcement, Interior Cabinet Secretary Dr. Fred Matiang'i said the computerized new generation smart number plates will have features including holograms, watermarks and laser markers, and will aid in stopping incidents related to motor vehicle fraud and theft.
Very happy that today, as we walked around and as we were taken through, we have witnessed transformation of our country in as far as the registration of motor vehicles concerned. The new number plates that are aligned to teams and NTSA programs as a journey towards dealing with insecurity in this country.
We are going to have new traffic number plates rules, which will cover about 12 categories of vehicles. And so today really is a very big milestone that what seemed a dream then has become a reality. It's so important to us because it forms a basis of monitoring movement of transport vehicles and other vehicles, personal vehicles.
Today is a major milestone to see this production facility, which is now bringing to life, or even bringing our vehicles and making them finally digital and accessible to our security services, to the insurance, to the banking, so that everybody can now be able to interact and work well with their vehicles.
We have the capacity to change, all the number plates in about a year or so. But I think NTSA is going to guide us, and we will patiently go through this exercise so that in the next 18 months or so, then I think we can agree with our colleagues in the police service that they then have to strictly enforce the Traffic Act of 2016 together with the amendments of it. We want them to have features that are identifiable by law enforcement agencies. We are meeting international standards in doing this. By the way, the international standards that we are supposed to adhere to when it comes to issuance of motor vehicle plates. The plates we have been having, by the way, did not comply with our international standards.
And across borders, the federal government of Nigeria has proposed a $750 million World Bank Ease of Doing Business Intervention Fund for 36 states of the Federation. Specifically, the fund will be used to reform the ease of doing business at the sub-national level. Details of this and more in our news from across the continent.
Nigeria ranks low in the World Bank Ease of Doing Business Index, a yearly ranking that assesses the business environment in about 190 countries using various indicators. The nation's poor rating on ease of doing business has adversely affected the economy, as many small businesses in the country have almost collapsed. Over 320 medium and small businesses have relocated to neighboring countries. Those still in operation are running at great costs due to high cost of production, insecurity, foreign exchange scarcity, and the opaque regulatory environment and corruption. The program seeks to provide additional stimulus, such as using results-based financing targeted at improving the business environment and facilitating private sector participation at a higher level. Meanwhile, Japan has promised a $30 billion investment in African aid as the TICAD summit came to a close. Speaking via video link, Japanese Prime Minister Fumio Kishida also promised to pressure for an African seat at the UN Security Council. The summit held in Tunis also served as a platform for business between Japan and the continent. The Japanese Prime Minister also announced that Japan would appoint a special envoy to the Horn of Africa, where a long drought has prompted the UN's weather agency to warn this week of an unprecedented humanitarian catastrophe. Kishida said Japan would also pump $8.3 million into the troubled but gold-rich Liptako-Goma tri-borders area between Mali, Niger and Burkina Faso that has been ravaged by extremist attacks in recent years. Finally, the Ghana government has signed a 25-year contract with South African company Telo DB Consortium to develop and operationalize the 299-kilometer Western Railway line. The consortium signed a rail management agreement with the government of Ghana through the Ghana Railway Company Limited to develop and operationalize the $3.2 billion Western Railway line. The investment will ensure that the rail infrastructure is upgraded and that there is interoperability of railway systems, new standardized rolling stock, required maintenance facilities, spare parts regime and operational integration into other transport infrastructure and systems.
Further afield, Toyota Motor Corporation said its July global vehicle production has fallen 8.6% year-on-year, missing its target for the fourth straight month. COVID outbreaks, severe weather and a recall probe on top of a persistent chip shortage impacted outputs. Here are those details of this story and others from across the globe.
The sustained weakness in overall performance in July from the world's largest automaker by sales has raised concern that Toyota may have to lower its annual production target of 9.7 million vehicles, even as China dials back pandemic restrictions and chip shortages are showing some signs of easing. Toyota produced 706,547 vehicles worldwide last month, below its target of around 800,000 units and the year earlier output of 773,135. Production in the first 4 months of the current fiscal year, which began in April, has fallen 10.3% short of its initial plan. Meanwhile, oil prices dipped on Tuesday, cutting off some gains from the previous session as the market feared that more aggressive interest rate hikes from central banks may lead to a global economic slowdown and soften fuel demand. Brent crude futures for October settlement dropped 56 cents or 0.5% to $104.53 a barrel after climbing 4.1% on Monday, the biggest increase in more than a month. The October contract expires on Wednesday, and the more active November contract was at $102.57, down 0.4%. Finally, Indian multi-billionaire Mukesh Ambani has announced a $25 billion plan to launch 5G mobile internet services in the country within 2 months. The high-speed network will be introduced first in major cities, including New Delhi and Mumbai. It will then be expanded to the rest of India by December 2023. The company is also working with Google to develop a budget 5G smartphone. The cheapest 5G-ready smartphones in India currently cost around $150. It is seen to be central to India's plan to transform the country into a $1 trillion digital economy. Serena Ndekeremo for Lunchtime News.
It's time to play now. Tottenham Hotspur manager Antonio Conte says his club needs at least 2 more transfer windows before they can challenge for the English Premier League title. The North London club will face West Ham United tomorrow in a league match. 4 league matches are on the cards today. Southampton will play Chelsea while Everton will be away to Leeds United.
On the other hand, Chelsea will be seeking to win 2 successive matches after beating Leicester City on Saturday, despite playing with 10 men after midfielder Conor Gallagher was red-carded. They will be counting on new signing Raheem Sterling after the English winger scored a brace in the previous game. At Selhurst Park Stadium, Crystal Palace will be at home to Brentford in a London derby, while Fulham will welcome Brighton.
Serena Williams extended her US Open farewell with a 2-0 win against Montenegro's Danka Kovinic at Ashes Stadium in New York. Williams, who is set to retire after the tournament, won in sets of 6-3, 6-3 and will play Estonia second seed Annette Kontaveit in the second round tomorrow. The 23-time Grand Slam singles champion, who is 1 short of Australian Margaret Court's all-time record for the second round. He is joined in the next round by Jack Draper, who beat Finland's Emil Rusuvu. That's all the time we had on KBC Lunchtime News. Remember, we are keeping our